Welcome to Looking at Legal Stuff. Today we have 13 hearings in a case of an extremely high conflict couple, where we join the case as they're finalizing a temporary parenting plan. But 9 months after that finalization, Dad returns to motion the court for adequate cause to change that parenting plan, and this time he brought a lawyer. He has a laundry list of claims against Mom that include that she has a boyfriend who's committed DV and who doesn't like children, that she's told her child that it'll be his fault if her boyfriend leaves, that she's pulled the child out of school to travel, that she's shown up in Dad's bedroom in the middle of the night and scared his girlfriend, who has a restraining order against Mom, and many other accusations I don't have time to share. Dad's lawyer accuses Mom of abusive use of conflict. What does Mom and her lawyer have to say about his accusations? Let's find out.
All right. Yes, I have parenting plans that have been provided by both parties. We're looking at temporary family law order, parenting plan, and child support. Correct. So I guess I'll give you each party a minute or two if there's any additional information you have. Otherwise, I'm ready to just make a ruling.
Okay. I can just note for the court that I did receive an email from Mr. Klopp, and I don't want to speak on his behalf, so he can confirm if I'm incorrect. But the email that I received from him indicated that he was agreeable to the majority of the holidays, with the main points of contention obviously still being summer, spring break, Thanksgiving, Christmas, and the child's birthday. Your Honor's well prepared for purposes of today's hearing, so I won't belabor the points. However, I would just note, and Your Honor likely saw in the most recent declaration, there's been some conflicts with transportation. Therefore, my clients request that a neutral location site of either the Castle Rock Police Department or the Park and Ride be utilized at this time, just given those conflicts between my client and the girlfriend of Mr. Klopp. But otherwise, I'll defer to the court if you've already reviewed all of the pleadings. I won't belabor it any further.
All right, thank you. Mr. Klopp, any comments?
Yes. Yes, she is correct with the spring break, winter break, summer, and Brody's birthday, and then also the transportation. That I disagree with. I don't think that we should change up what we have going, other than to change it to pick up after school on days that he does go to school, and then to pick up at 7 p.m. at each other's houses. The only issues that we have been having have been caused by Lacey, overstepping boundaries and disrespecting our privacy. So if she could just remain in her truck, I feel like those issues could go away. Just like yesterday, everything was fine because she remained in her truck and she respected my privacy, and everything was fine. So that I feel like that could be avoided if she just would respect our privacy.
You were asking for a different pickup and drop off time.
Yes.
I think you said 7 and she was suggesting 6. Is that correct?
Yes, Your Honor.
Okay. And is 6 a problem with your work schedule or anything of that nature, or?
No, just our family dinners and stuff. It just seems like I get off work at 5 p.m. and by the time I either pick Brody up or my other children, it's almost like 5:30 already. And then if we have dinner already at home, it just doesn't really give us a whole lot of time to eat dinner as a family. We're kind of rushing him out the door with food in his mouth a lot of the times. So I just ask for an extra little hour, but.
All right, so here's what I'm going to do. I'm adopting, and I'm working off of Miss Bliss's paperwork, solely because some of the language that's in there is language I'm going to adopt. So I have a temporary family law order. I'm adopting that as proposed, which is I think the same as what Mr. Klopp proposed. In the parenting plan, joint decision making across the board. At this point, given the concern between mediation and court, I'm going to have the any dispute resolution go to court at this point. If there's an agreement to change that later, that's great. I am going to have the exchanges every Monday. I'm going to make that 7 p.m. Or otherwise agreed upon. I am going to adopt the request as far as summer. So each, excuse me, each parent can have 5 days with the child during summer, and that'll to be scheduled with the other parent no later than May 15th each year. Given the child's age, I am going to adopt the spring break schedule for on a temporary basis that is proposed by mom. So half a week to each parent. Just want to make sure I hit on all the areas of contention here. There was a concern over
Thanksgiving, I think, is the next holiday on my list.
Proposal from Miss Bliss, Wednesdays. I'm going to just change from 6 p.m. to Wednesday after school to Friday at 9 a.m.
Was that for Thanksgiving, Your Honor?
Yes.
Okay, thank you.
For winter break, or Christmas break, I'm going to change. I'm going to change what's been put forward. I think exchanging on the 23rd, the 24th, the 24th, and the 25th. I think that's just a lot of exchanges for a young guy. So I'm going to change that to even years to the father from date school is out to noon on Christmas Day, with mother from then until school resumes. Odd years would be the opposite. What I do foresee is that may impact the week on, week off schedule somewhat. So if that resets it and somebody gets a day or two extra time, I think that's something that we just need to understand may occur, and hopefully it won't become an issue. And then the last one is the child's birthday. And I'm going to adopt the recommendation of Miss Bliss at this point. So father will have him 8 to 4, mother will have him 4 to 8 the following day, and then that'll reverse. So each party will get an opportunity to be with him on his birthday. For transportation arrangements at school, this should go without saying, but any outside influences on exchanges, any non-parent involvement in exchanges should be courteous, kind, respectful of the young person that's present, and respectful of the other parent that's there. So exchanges will be at school, and or the home of the party. I'm not going to do the park and ride at this point.
So, Your Honor, my only concern with that is Mr. Klopp's girlfriend has just recently sought a protection order, which obviously would prohibit my client from going to her home, which she also shares with Mr. Klopp. So assuming that goes forward, I mean, I don't know what her intentions are, if she plans on dismissing it or moving forward, but assuming if that moves forward and for whatever reason is granted, then obviously that would impair the ability to have the exchanges at the home of Mr. Klopp.
Well, that does throw a wrench into it. So I will revert back then to the park and ride, and that's the Castle Rock Park and Ride. Is that correct?
That is what I have in there, yes, Your Honor.
Sorry, I already whited it out.
Your Honor, can I say something on that?
If there's an active no contact order, then I can't do anything about that. That was your girlfriend's choice to file that. That protects your home, and she can't come within a certain distance of your home unless that order's gone. So Castle Rock Park and Ride it is, or the school.
Okay, thank you.
I don't believe there were really any other issues with the remainder of that, so I'll sign that order.
What about child support, Your Honor, or were you just?
I'm getting to that right now.
Oh, okay, thank you.
So, obviously this is the area where there was the most disparity. There was a significant difference in the petitioner's wages, depending on whose worksheet you looked at. As far as the order, what I didn't see, Miss Bliss, was any kind of deviation as far as for essentially a 50-50 schedule. And I indicated, or you indicated, that no party asked for that. And I think in the initial response, there was a request for a deviation for the parenting time. So I guess if either party wants to make any comments regarding that,
I'd be happy to, Your Honor. Obviously, it's my client's position that Mr. earns a substantially higher wage than she does. As Your Honor's aware from my client's declaration, she has been diagnosed with fibromyalgia, is incapable of working full-time wages. She does have a job where she's working $30 per hour, but it's only at 26 hours per week. So I think that's the largest contention with our worksheets is Mr. Klopp has indicated that she should be imputed at 40 hours. Obviously, there's nothing to reference, and even in his declaration supports that historically she's never worked full-time wages. So it's our contention that my worksheets are appropriate. As for deviation, when the court is determining whether or not to apply a residential credit, you have to look at the incomes of both parties, the homes of both parties. My client provides for the court that without some child support, that she doesn't have sufficient funds to support this child. As Your Honor can see from the child support worksheets, he earns drastically higher wages than she does. He did provide a budget, I saw in his responsive declaration, but it doesn't take into consideration his girlfriend's income, which he acknowledges she lives with him, assists with the bills and the paying of the rent and utilities and the like. So at this time, we're asking the court not to order a deviation. If Your Honor is inclined to order a deviation, I don't believe a zero transfer payment is appropriate in this case, just given the incomes of the parties. So depending on what Your Honor decides to do with that ruling, I can rerun a deviation or prepare another order.
Can I respond to that, Your Honor?
yes.
Okay, to start with, Lacey has worked full-time in the past. She was working at Happy Kids Dentistry when we first got divorced. I supported her until she got that job financially and fully. And then she has had a few other jobs in between since Happy Kids, Jamie's, and some other jobs. And then if she is fully disabled for that, how come she hasn't provided any paperwork for being disabled? I feel like that should be provided if she's fully, oh my goodness, oh, disabled. The Brooke, she does work, but she only works maybe one day a week, not even. Sometimes she only works once a month. Sometimes it's once a week. Sometimes it's twice a week. She goes to school full time for nursing school, which is super expensive. Lacey fails to mention that she has a working boyfriend from home too as well. So I think if we're going to consider Lacey's income, I believe that we should consider Lacey's boyfriend's income as well, who lives there full time. And then I also have a 7-month-old daughter that I take care of full time too, financially.
All right. So here's what I'm going to do. I am going to order at this point that there be a transfer payment given the circumstances. I am going to deviate from the calculation. Both calculations. I think there was one party landed at 824, one party landed at 879, something like that, without the deviation. And then I think Mr. Klopp's suggestion with the deviation would be a minimal transfer of, I don't know, $100 or so a month. This is child support. This isn't spousal support. I'm going to, and I think we were sitting at $300 a month. Was that what the previous amount was?
Yes, ma'am.
All right.
Was it 300? Okay.
I'm going to set support in this temporary order at $500 a month, and that'll I'm going to have that start March instead of February.
We're just going to interlineate that on my order,
Yes.
or do you want me to compare new? Okay.
I won't enter the worksheet, but I'll enter the support order based on that.
Did you say you weren't going to enter my worksheet? Sorry, I just want to make sure.
Yes, correct. Just
Okay,
the,
did you want me
just
to
the order.
prepare?
If
Did
you want
me
to prepare,
new worksheets?
please, and then I will happily sign those ex parte and enter them to, or send them to the clerks.
Were you adopting either one of our incomes for the other party, just so I know which numbers to put in where? Or do you want to adopt my worksheets and then I can prepare a deviation and submit
Sure,
that?
let's do it that way. That'll probably be the
Okay.
easiest.
Okay, I can do that.
All right. Good luck. Thank you. All right. And Clop 19-300361008. All right, so this is, excuse me, Miss Bliss and Mr. Klopp. There was a request for clarification. There was also a request for reconsideration, but they were largely similar. So I'm assuming that the clarification is really what's being sought here. And the main issue is the two different paragraphs within the parenting plan that say 7 p.m. exchange and then after school, or when school is in session after school. So I've reviewed everything and the order very specifically on page 3. Section 8B1, the exchange is at 7 p.m. So it's not after school every Monday. It's at 7 p.m. every Monday. So I don't know that the order needs to be changed to rule to, but that's what it is. I understand the concern and the confusion because the section 12 states they'll be exchanged at school when in session or Castle Rock Park and Ride. So there are times in the parenting plan where school is the point of pickup and drop off, and that's namely in some holidays that are covered here. But as far as the regular week on, week off schedule, 7 p.m. Mondays at the Castle Rock Park and Ride.
Okay.
Is there anything else that we need to clarify so we make sure we don't have any issues? Go ahead, Mr. Bob.
Oh, sorry. Yes, there is, Your Honor.
Sure.
To start with that, there's no way you could reconsider that to be picked up after school. Or is that just out of the picture? Changing that to after school rather than the 7 p.m. Just to limit all interactions if we could. Just because of the restraining order that's in place for one, and then for two, just so we don't have to do as little as interaction as possible.
Ms. Bliss.
And Your Honor, as contained in my client's declaration, it was specifically anticipated, that their protection order was already in place or was going to be in place. Your Honor still ordered that the park and ride was to occur consistent with that. There were specific discussions during that initial hearing that Mr. Klopp had requested the exchanges occur at 7 instead of 6 is to not interfere with dinner time. So it was fully anticipated that the interactions would occur at 7, which is essentially status quo. It's an hour different than what the parties had been used to. There's no basis to make that request currently. I understand that he brought a reconsideration, which I think the court is aware this isn't the real proper venue for that, as those are typically done on the pleadings. But nevertheless, there's no change of circumstances between the last hearing and today. There's no real basis to switch that at this point. And so we would ask that it remain as it is, as it was fully anticipated and fully considered at the first hearing.
So, and I'm reviewing, Mr. Klopp, your initial request when we went into that hearing a couple weeks ago, and your request, initially it was 6, then it was 7, You specifically asked for it to be later, so dinner could be concluded. When the exchange happened, there was never a request in my notes or in the court record for after school exchanges. Frankly, I have no idea what that restraining order is about, why it was filed. There should never be an issue with exchanges between parents, step parents. It should be civil.
Right.
There's a child present, so I don't know what the issue is, but
Just, oh, okay.
that's so I'm not going to change the 7 o'clock. It was what was
Okay.
contemplated and requested by, frankly, by both parties. So I'm going to leave
Okay,
that at
thank
7.
you.
Anything else, Mr. Klopp?
Yes, and then the New Year's Eve schedule, I feel like also kind of interacts with the winter break schedule. I feel like that, let's see here, sorry, it's so, winter break. Oh yeah, so the spring break will roll over, or the spring break day, or sorry, not spring break. Oh my goodness. New Year's Eve. Isn't that's still in the winter break? Is that how that works?
Generally, yes. So are you confused or concerned about essentially an added exchange in the
Yeah,
middle
so
of
there
the
would,
second
there
half?
would be another exchange in there on my year or her years. That, so if it was like my winter break for the last part of the winter break, Lacey would be getting him again on New Year's Day. Yeah. Are you seeing what I'm saying?
I am seeing what you're saying.
Okay.
Ms. Bliss?
Not sure.
And Your Honor, I didn't really take a position on this. Your Honor made the change as to the Christmas Eve and day schedule, providing essentially for a Christmas break split schedule. It's not uncommon that we celebrate Christmas or New Year's, even with the inclusion of a winter break. I don't think there's a real basis to make a request to make a change, but I'll defer to Your Honor.
Is this the concern just the exchanges?
Yeah, just the fact that yeah, like he would be like, if it was my winter break still, he would go back with his mom for one day for New Year's Day. So if we could swap the years, that would change it, or the wording to where I could just have him the full winter break, which is, could we add like the New Year's as part of the winter break, I guess is the easiest way to put it, rather than having the swap.
Does Ms. Bliss, does your client have a strong position on that? Like New
No, Your
Year's
Honor.
Eve isn't like a big family, okay. Because
Not
to
to my
me,
knowledge.
the easiest thing to do would potentially be just on the New Year's Eve portion, just in odd numbered years with father, even numbered years with mother. Because then it would essentially be consistent with, or it can just be struck. So I'm fine taking that out if neither party has any strong feelings about New Year's Eve. So Miss Bliss, I know you're leaving soon, but I guess I would ask if you think it would be easier to just strike the New Year's Eve portion.
You can do that.
And then the best way to do that, to keep a good record, do you want me to do a bench order, or do you want to present something ex parte?
I think it might be cleaner to just strike it from the parenting plan and just submit an amended temporary parenting plan. So that way we can just refer to one parenting plan instead of a parenting plan, a bench order. I think it's just cleaner and less confusing
Okay.
that way.
All right, well, I would hope that since all we're doing is printing and omitting, we can get a signed order, an agreed order from the parties, and I will sign it and file it as soon as I receive it. So Mr. Klopp, can you work with Ms. Bliss's office on getting your signature on the order that will just omit the New Year's Eve language?
Yes, ma'am. Yep. We
All
can do
right.
that.
And then once I receive it, I will file that.
Cool. Awesome.
Anything else?
Yes, and then my biggest one also was the first right of refusal. So on days that I do work, Lacey still hasn't given me a schedule of her work. So I have an issue with giving him to Miss Dahlman when I'm at work, because I don't know if she's at work or not. I feel that it's not beneficial to Brody for him to go to his mom's house while she's at work. I know she works from home, but I still feel like he just gets stuck having to play video games or do things that aren't very proactive for him when she's working. And I don't know what days or what times she works, because there's never been a schedule given to me. She knows my work schedule. I've worked the same work schedule for 8 years. Hasn't changed. I can leave work anytime I want. My work is amazing. I just feel like the first right of refusal, I feel like if he has the opportunity to go to a grandparent's house or have my fiance watch him with his other siblings, I feel like that should be an option rather than have to go sit with his mom while she works. I just don't feel like it's very proactive for him or good for him to have to do that. On days that she's not working, that's fine. I understand, but I have yet to see a work schedule.
Ms. Bliss?
Your Honor, as my client has testified in numerous declarations, she does work remotely. She works when the child is in school or otherwise not in her care. It's my understanding there is no issue with her working if he needs a work schedule be provided to him. I don't think she has any objection to that, although it's not the order of the court. The order of the right of first refusal simply states if a parent is unable to do so or is working there to afford the other person the opportunity to watch the child, not I need to give you my work schedule, you need to give me your work schedule, and then we'll coordinate. That's just not typically how it works, and that's not what the order is. If that's what Your Honor is going to order today, my client has no objection to that.
I'm not going to order that. I think it's beneficial to share that information. I'm not going to change the right of first refusal. I appreciate other generational family members being involved in these kids' life. I think that's very important. But it's a relatively common ask. And even with the concerns with the exchanges, I'm going to leave it in there. And I would just hope that if she's willing to provide her work schedule, that's something that they can find some mutual grounds on. I agree that, I think the order says over 4 hours. Is that right? I think it's over 4 hours. If they both agree that, okay, it's going to be 4.5 here and there, and it's okay to be with grandpa or whatever, that's fine. But I'm not going to change the order as it is. That doesn't mean that you can't work with each other on figuring out how to best approach that for your child.
Okay, so just contact her and figure out if, hey, can you go spend the day with so-and-so, or I guess.
I think communication is important. And so, I mean, she has a right to say, I want to take them for that 5 hours that you're not available because of the order. But if you speak with her, and she also has a right to say, no, it's okay, you can take them to grandpa's, or you can, so my hope would be that you'll learn to work together for the best interests of the child.
Okay.
All right. Thank you for raising these issues. If you, it's good to get clarification when you need it. So
Right.
hopefully this helps moving forward.
Awesome. Thank you so much. Appreciate it.
All right. Good luck.
Thank you.
Mr. Klopp, I will send that to you after court this afternoon with that removal of the New Year's Eve language. So if you could just review that and give me your signature, and I'll submit that to the court.
Will do. Awesome. Do I need to bring it to your office? Sign it and bring it to your office? Or?
No, and I can send it to you via electronic signature. We'll put that in the email as well. So if that's easier for you, that's fine.
Awesome. Thank you so much. Appreciate it.
All right.
Thank you, Judge.
Or set over.
Yes, Your Honor. A request for continuance. Aaron Winkles appearing on behalf of Jennifer Joslin and Klopp v. Klopp. I know it's contested though, and that's 19-3-00361-08.
Yes. All right. And I did see, did receive the declaration from Miss Joslin. Miss Baldwin?
Thank you. So in this matter, we've already waited for 3 weeks for the hearing today. My client does want to move forward. The concerns here are that there's a very clear adequate cause. We have 2 restraining orders that have been entered within the last year against the petitioner. And then my client details the violence in the mother's home, domestic violence, with direct screenshots associated with that. Domestic violence in the home, putting the child at really direct risk. Similarly, child witnessing this behavior, witnessing the behavior that resulted in the restraining orders, significant instability on the part of the petitioner, and just kind of glazing over the surface of those arguments. There is a reason in this case to go forward and protect this child. What we would recommend, instead of just straight continuing it, is instead based on the materials provided, is to grant adequate cause, to adopt our order as an interim order, and not to deal with child support at this time, and to set it over only for the purposes of entry of a full temporary order. Both sides can then argue what that temporary should look like, appoint a guardian ad litem, but that we should take steps to protect this child now, given some of the very concerning aspects regarding domestic violence in that household, and the 2 restraining orders that were taken out and entered by the court against the petitioner. And this is a case where the child's at risk by waiting. We've already waited 3 weeks. Waiting 6 weeks just isn't reasonable. Putting the child at risk for another week isn't reasonable.
Okay, Ms. Winkles? Thank you.
Yes, Your Honor. The fact is that they've waited almost a year. And the reason I say this is because there have been a number of opportunities, if they were really concerned about this, to do it at the time of the first protection order, at the time of the second protection order. There have been so many opportunities to bring up this issue that to then wait and say, we're going to give you the 3 weeks, but there's no counsel in Cowlitz County that are taking new cases. So the counsel that took this case, who I'm stepping in for, Jennifer Joslin, is in Clark County now at my office, came in on the 20th. So to grant adequate cause without any sort of ability to defend oneself, when we don't know if there is adequate cause, it's strategic. And the problem is that this should have been dealt with in any of those protection orders if there was an issue. Why were those protection orders updated and amended, but nothing was referenced about mom? It makes sense. Miss Joslin is not asking for a significant set over. She's asking for 2 weeks. The child, in the last 3 weeks, there have been no police reports. There have been no issues. There have been, the child's safety has not been an issue in the last 3 weeks. To have another 2 weeks when the child's been in the mom's home repeatedly over the last year without incident seems to be a problem. Additionally, it needs to be noted that he filed for modification in October, and court for that was in March, and it was not brought up at that time. So why is that? And why are we doing it now? It seems strategic. It's right around Christmas time. It's right after the holidays. There are no attorneys. So, Your Honor, I would ask for an extension for Ms. Joslin, and I know nothing about this case minus what I just read about 5 minutes ago. Allow Ms. Joslin the ability to get a declaration from her client, again, hired immediately before Christmas. 2 weeks is sufficient as long as she's given a week to get that declaration. We can make it shorter, but I'm not sure how that would be possible unless there was no reply or the reply was due only a day before.
What parenting plan are we currently operating under? Because I'm looking, excuse me, and I see one from April 12th, 2023. Is that the only plan that's in place?
There's one in March.
Yes.
And yes, so there's one in early spring 2023. So it's a 50-50 plan currently.
And that was the modification that was done in October. And
so the parties always had a 50-50 plan. The modification was a minor mod to, they had a sort of a pro se 50-50 plan with lots of loosey-goosey language. The initial minor mod was to set some really firm boundaries, and that's what the spring 2023 plan did. It didn't create a 50-50 plan. It just sort of made things really clear about who was to transfer and when.
All right.
And at that time, just so your honor's aware, he requested the 50-50 plan continue. But when you look at the declaration now, we go well into the past. We're not just talking about March and forward. And yet in March, he requested as well the 50-50 plan continue because he was the one that filed that.
The restraining orders all happened subsequently.
But some of the issues involved appear to be before March. And again, I know very little of this case. She's in the adoption docket.
So I was able to read most of this, not all of this. Not everything got into Odyssey before I was out of the office last week. I had a little bit of time after my docket this morning before today, and I had bench copies waiting for me. I was able to go through a lot of it, not all of it. And I saw the declaration. I do understand that there is a shortage of attorneys, and especially at this time of year, that can be difficult.
I've not read the declarations, so I would have absolutely no ability to argue this whatsoever. I just stepped in for continuance because she's on another
The
docket.
declaration I'm referring to is your Miss Joslin's declaration for continuance.
I haven't read that either.
And I understand the concern. I can't say with certainty, based on some of this information, there is question about dates and how old or new some of these allegations are. There's a lot of photographs that were provided of concerning images of the child, but no, I don't have dates for when that was. Obviously I have concerns, but I do think it's appropriate to allow time to respond. If it took time to get Miss Joslin on board, I can definitely understand that. So I'll probably do something that makes nobody happy. I'm going to give a continuance, but it's only going to be until the 2nd. There's enough information in the information that has been received by the court that I think it does need to be addressed sooner rather than later. And so we'll set this over 1 week to the 2nd. I'm assuming based on that, the responses can be late from Miss Joslin, and those can be served as bench copies to the court in whatever manner she feels is appropriate. And I'll just make sure the next judicial officer is aware of that because of the timing, but I think we need to address it sooner than later.
Can we make her response due Thursday by like midnight if she's just e-serving it? That gives me a single day to essentially get out a reply because Monday is a holiday.
Oh, I think that will be fine.
Let's shoot for that.
Okay.
Thursday by midnight.
And I appreciate, I know I'm putting everybody under the wire there with that order, but I think resolution quicker than not is appropriate given the allegations.
That's fine. Thank you, Your Honor.
Very good.
All right. Thank you.
All right, that brings me to Klopp v. Klopp 19-3-00361-08.
Very good. That matter's ready, Your Honor. And just for procedural, so this was on last week, but timely. The court set it over a single week to allow the non-moving party to respond, but gave them essentially till Thursday at midnight. My pleadings then were Friday. We did, looks like there was some confusion with the email copy, but we did provide a hard copy as well to the court. Did the court receive our reply documentation?
I received your hard copies. I just did not receive the others, unfortunately, but that's fine. I finally found the email. I'm sure it was just the holidays, but no, because I worked yesterday, I didn't have anybody to ask to see where they were. So it was solved. I was just more concerned I didn't find them.
All right, very good. So with that, for the record, I'm Chelsea Baldwin. I represent Stephen Klopp. This is our motion for adequate cause as well as temporary orders. I'll note again, just procedurally, there was a previous minor modification where adequate cause was found for that approximately a year ago. the conditions have significantly deteriorated, resulting in us filing for a full adequate cause for a full modification. There was some objections filed to pleadings. I'll note that the objections filed to my pleading are a misunderstanding of the local court rule by opposing counsel. She read the rule to mean that you could only have your client's declaration and 4 single sheets of paper in addition to that for the witness declarations, instead of your client's declaration and up to 3 additional declarations of 4 pages each. And so while I have one declaration that runs over by a single page, I didn't then produce a 3rd declaration. So essentially I'm well under my total page limit. Counsel then used sort of that single page, and again, under the limit, to file 13 additional pages of her client's declaration and about 70 pages of documents attached to those. She did those with a statement on parenting plan and then a supplemental declaration. I don't think the court should consider those. Additionally, I made evidentiary objections as to the declarations of Jackson and I think it's Remus, just lack of foundation. Neither of those people say they have any personal knowledge as to the specific sections that I called out. That being said, I'll just leave it to your honor to sort of make your internal judgments about what you reviewed and what you didn't. So in this case, we are asking the court to find adequate cause, and we're asking the court to place a child primarily in my client's home. It's currently a 50-50 parenting plan. The biggest risk to the child at this point is domestic violence that's occurring in the petitioner's home. The petitioner has a live-in boyfriend. He has a criminal record that includes assault history. And really concerningly, we have Miss Dahlman or Klopp, the petitioner, calling out to the boyfriend's sister. So she's calling someone that's a relative to the boyfriend, saying she's scared of him, that he's throwing empty liquor bottles around the house, that he's putting the child in a locked room and locking the child into a room. That when he gets mad and angry, he's breaking things in the home. Again, when he's angry, clear signs of domestic violence. And then we also have threats of violence, and we have these directly in text messages. And these are not, they're not unclear. The threat is, I'm going to put you and the child in a cardboard box. And it's very clear how the petitioner took that threat, that was a direct physical threat. She's trying to twist that into something else now, essentially using, and we know this because it's in her text messages that she submitted. So this isn't a he said, she said. We have it in the materials the petitioner submits, where there's an acknowledgement by her and boyfriend that this was said. So again, huge concerns here, especially when you have the level of domestic violence where things are being thrown around the house. We have him breaking things in the house. And the conditions were deteriorating to the point where the petitioner called my client and his household 37 times within just a few days, reaching out for help. And my client's like, of course I answered the phone. Of course we called her back when we missed those calls, because she had the child. And in a week on, week off situation, you're not going to ignore that when she's reporting violence in her home. So my client is, of course, answering the phone, trying to problem solve, but without an order for him to be able to do much about it. All he can do is offer solutions. And ultimately, the petitioner doesn't take any of those solutions. She decides to remain in that abusive relationship. Again, really significant concerns that we see marks on the child that are unexplained, or where the explanation shifts over time. And that happens even in her statements to the court here and her pleadings. Marks that just don't make any sense, and the explanation's not making any sense. Bruises, black eyes, things that don't really match normal injuries to a child. Bruises on shins and knees, I don't think I have any concern. When you see bruises and marks on somebody's neck and face and black eyes, those don't match normal childhood injuries. And the explanations don't match. And again, when they shift, that's a huge red flag that this child is suffering in this home. Again, my client reports he knows the boyfriend, that the boyfriend does not like children, and that is adamant that he does not like children, and he does not write a declaration here. Her main partner, petitioner's main partner, main live-in person, writes no declaration otherwise, does not dispute any of the allegations that are made, nothing. And the lack of evidence here is a statement. And I would say a number of the things that were presented by my client are really not denied. There's some attempts to sort of excuse them away, or gee, child really likes this person. Again, children are not going to bite the hand that feed them. They don't have, and especially young children do not have a lot of options in a household like this. They have to put up a good front because they know the consequences when they don't. So children like this, I'm going to stay in my locked room. I'm going to be quiet. I'm going to avoid getting hurt. And so there's not a lot of choices children this age have. It's notable that in the text messages submitted by petitioner, she states unequivocally that she told child that essentially if her and boyfriend break up, that it's child's fault, that, I wouldn't blame him if he left us. So and these are words she's telling my client, hey, I told child this. I'm blaming child, putting this full weight of my adult relationship on this grade school age child, which is incredible. And again, she admits this in the text messages she submits. So again, we have this incredibly toxic and abusive relationship, but we also have a parent that's putting that level of weight on this very young child. My client reports child having some behavioral issues, some difficulties, and that's not surprising given the environment in mom's household and the struggles the child's having there. So the very first thing we have here is a significant, very real safety threat. That's followed by evidence of really extreme imbalance on the part of the petitioner that's resulted in not one, but 2 protective orders within this last year. So we see the original protective order that was entered in March of 2023 due to the petitioner's behaviors of just harassing, stalking, repeated behaviors that just were not abated by the normal, please stop, please stay away. Couldn't get her to do that. So district court enters an order that says stay away. But that does not solve the problem, sadly. We see subsequently to that, so get an order, all of the things that my client sort of spends the majority of his declaration and his significant other's declaration happened after this March order. And those are things like entering my client's home uninvited, so just walking right in, opening the door, but going so far as to do this at night when my client and his spouse are sleeping in their bed. They wake up to her hovering over them as they slept. I can't imagine how unnerving that was for my client to wake up and here she is in their bedroom. So she made it through not one, but at least 2 doors at night. So again, these are really extreme behaviors. We have the petitioner throwing things at my client's significant other. Again, entering their home multiple times to the point of, walking. My client says we were in the backyard. She walks all the way through the whole house and enters the backyard. And, we're all of a sudden shocked to find her there. Evidence of stalking where, again, it's a week on, week off parenting plan. And she's there at the child's school when it's not her time, essentially just watching the pickup, driving by my client's place of employment repeatedly, driving by stepmom repeatedly, over and over again. And these are often with child. In fact, the majority of these actions are with child in tow. These actions are so significant and so repeated and ongoing that the order gets moved to Superior Court and an additional protective order is entered. That happens in November of 2023. And not only is it a more restrictive order entered, but it's expanded in time to last longer because, again, these issues are not abated. And unfortunately, my client and the significant other report, it's still not abated. There's an order that is essentially at these exchanges, you can't come to the house anymore. We have to do them in a parking lot, stay with your vehicle. And instead of staying with the vehicle, it's, okay, now I'm going to walk all around and kind of play this, well, so long as I'm not, within 30 feet, I can't get in trouble. But the problem is kids in tow for all of this. Child's watching all of this and all of this behavior that's really unhealthy and unhinged. That doesn't make any sense in the context of what's going on, other than for it to be a continuing level of this harassment and just creating conflict where none needs to exist. I'll note there's indications that the petitioner herself is just unstable, and that's the underlying issue. Really, is an instability that's resulted in all of this behavior that's been ongoing for, at this point, more than a year. We see multiple job changes, her getting fired, her quitting in lieu of getting fired. There's a whole number of issues that sort of, my client reports some of the symptoms, but you see also some of the outflow of that in petitioners' regular daily living. So again, huge concerns there. My client also reports that the child was with him more than the scheduled time, which I think is important, that even though it was a week on, week off plan, that my client or my client's family had the child every Thursday and every Friday for an extended period of time. Mom then realized she wasn't getting, that she had the child maybe only about 40% of the time. So then said, well, I'm going to take that away and create a cost and put child in daycare instead of allowing my client to have child during his time off and for a family member to care for the child, even though that had been going on for an extended period of time. And again, what we see there is just that abusive use of conflict of, I'm going to create conflict because what I want isn't happening. There are issues with neglect. We see some issues with medical neglect. Again, child at this point, he's not the 99th percentile for weight, he's over that. So he's past the chart where the chart is going to graph him. They just don't go to 100%. It just stops at more than 99. She tries to sort of clean this up saying, hey, he's always been a stout kid. The previous record is one from about 4 or 5 years ago. It shows the child's at the 90th percentile, but that's tracking relatively close to height. But now we see that's jumped up more than 10 percentiles and child's no longer tracking. My client reports child having difficulty eating sort of normal everyday foods because mother's household doesn't eat those foods, eats foods that are essentially entirely fast food. That might be, while not healthy, might be fine in a normal context. It's not fine when a child's into the obese category and isn't healthy and has the manifestations of that. Child's huffing and puffing when he's exercising, when he's playing, when he's doing normal childhood activities. He's suffering for this. And that's not appropriate nor fair to a child this age who doesn't have control over their diet. Children that are grade school age children, they're really almost entirely reliant on their parents to make these choices for them. A child 50% of the time is being forced into very poor choices. Notably, my client wants to involve the child in activities, continue things. Last year, the child's involved in wrestling. It's physically active, it's healthy. By some of the witness declarations, he enjoyed it and had a great time. Mom says no. And I'll just say no, it's I'm going to wait. I'm going to not answer. And she said, well, my lawyer answered 2 weeks. It took 2 weeks to get that answer. And so again, I'm not going to answer dad. My attorney I'm going to wait to answer my lawyer because this is not an issue where the lawyer isn't communicating that. I don't believe that. I'm going to wait. And again, it's that abusive use of conflict. I'm going to have child sort of forfeit being able to participate by just not responding. Similarly, child's facing educational neglect in mom's household. In a 50-50 parenting plan, we see this child who both sides admit has some struggles with reading, and yet mom pulls child from school at least 2 times for two very substantial periods of time for the child to travel for reasons that don't make any sense. One, and again, not denied, was to help petitioner's mother in her divorce. So grandmother's getting a divorce and child's forced to go along and miss school. And my client very clearly says, don't do this. You can go, but don't do this. Child's missing school when he needs to be there. And mom says, I'm doing it anyway. Similar instance where child then travels to Colorado and mom sort of just blows it off. But when we have a child that's struggling, we don't take them out of school and cause them to miss school when they desperately need to be there. There are concerns about mother's mental health. And again, that really goes into the instability. Mother sort of denies depression and anxiety, but out of the other side of her mouth, a page later in her declaration, admits to sobbing in front of the child and says, and her quote is, insane levels of stress. those are indications that she's not doing well. When you're crying in front of your child and your child is distressed, that is a problem. So in this case, there's plenty of factors that warrant the adequate cause, and there are plenty of safety factors that clearly warrant a change in the current parenting plan from the 50-50 to what my client has proposed. He's proposed a plan that minimizes conflict, and that's really one of the main goals here, is to minimize conflict, minimize mother's opportunity for abusive use of conflict as much as possible. When it comes to child support, we provided my client's wage stub, and that he makes essentially $6,800 per month net. We didn't have any information for mother, so it's hard to create a child support worksheet from nothing. Subsequently, she provided documentation that she's making $30 per hour. We just asked that the court impute her at $30 per hour full time. That would put her at just about $5,000 per month. That's gross. I haven't figured out the net yet. Normal taxes should be applied to that. Mother does appear to have a second job. So she's got a primary job, and then it looks like she's got a secondary job that's it looks to be sort of like a travel agent, that they're selling travel packages. That should be at an additional $500 per month. Again, gross, based on what they've put her at or what they've provided in their documentation. So that would make her a total of $5,500 per month. Again, gross, not net. Child support should be based on those figures. So again, at this point, we're asking the court to find adequate cause, given these facts, including so many of them essentially admitted by the petitioner. The court should place the child primarily with my client, adopt my client's proposed parenting plan, order child support as we've proposed, and appoint a guardian ad litem.
Response?
Yes, Your Honor. Thank you. In regards to the objection that we filed, it is our understanding, as through various brown bags, that the local rule states 4 pages in length total for declarations, which is what we went off of. But if Your Honor is stating that it is 4 pages per the 3 declarations, we understand there is still over the limit. They went 6 pages on Brooks' declaration, so we are objecting to that, asking that it be stricken. In regards to everything that opposing counsel has brought up, I don't want to spend the court's time sort of rehashing this, but the vast majority, if not everything, has been brought up prior. All of these things about 50-50 time and all of these allegations about the boyfriend has all been brought up prior. This is all raised judicata. They're now trying to raise it again, trying to get a punch in. We have the parties who entered a final parenting plan on April 24th, 2020, a temporary one on March 14th of this year, and an amended one on April 12th of this year. None of these final plans had any 191 factors in them. None of father's proposed parenting plans up until the current one filed in December even had a proposed 191. And with that, on father's proposed, there's no domestic violence. There is abusive use of litigation and mental health. There is no other indications such as addiction. So this DV, this addiction, all these things that they're saying, 1, it's already been adjudicated, and 2, father didn't even put it in a proposed parenting plan or raise it. If father really thought there was all of these issues, why would he sign off on a parenting plan with everything? Each of these parenting plans, no 191s and a 50-50. Nothing that they have submitted in their declaration or said today has occurred after the parenting plan of April 12th, 2023. This was all prior to this. It really, at this point, just appears to be gamesmanship and strategy on their point, when all my client's trying to do is do what's in the best interest of their child. She just wants a resolution. There are a bunch of allegations and sort of general statements listed in Stephen's declaration and Brooks' declaration that don't have any timeframes. They're just these general allegations. So it's really hard for my client to defend and really state when equivocally this allegedly occurred or didn't. But I think it's important to touch on some of them, especially as opposing counsel brought them up today. One of the ones is the boyfriend. The boyfriend, Mitchell, and Stephen had a long-standing friendship. The assault that was here was 10 years ago, prior to the final parenting plan that he signed off on. This was never an issue with Stephen. This was never brought up. He allowed Brody to be around Mitchell the entire time that Brody was alive. It only became an issue suddenly right now in December of 2023. We have a declaration that states it's likely that Mitchell was not the aggressor, that Mitchell had been hit before by the prior girlfriend. The child and Mitchell have a very close relationship. They do a lot of things together, the hunting, doing cars, walks, all of that kind of stuff. This is not the child who is scared of their abuser situation, as opposing counsel states. It's a child who truly loves his stepdad and calls him stepdad. He's not pretending he likes it to survive in a home. The allegation that Stephen had the minor child more than 50% of the time. Again, this is an allegation from 2020 that's already been adjudicated. But since they brought it up again, that's not correct. My client had the child every day up until they separated. She went to work. Then the child went one day to Stephen's, one day to his mom's. And that when the child got older, my client wanted to integrate the child into daycare to do the normal things, socialization, all of those things, not because she was trying to have abusive litigation. It was just the normal sort of how a child goes. My client, yes, has she been upset? Of course, but crying once doesn't mean let's take her child away. My client's been battling opposing party and his fiance for a year, from allegation after allegation after allegation. It's not unheard of that someone's gonna get upset. She's not sitting down the child and then all of a sudden turning on the waterworks to make the child uncomfortable. The child is a very sensitive child who, if he sees anybody upset or cry, is gonna ask what's wrong. We have opposing party who's accused my client of lying, who's accused her of lying the entire time, but she's proven every step of the way that she's not. Stephen says, oh, my client doesn't have fibromyalgia. She made this up. We've submitted her health records to show that she does. He's accused my client of neglecting his health when he's the one who basically called the child obese in front of the child at the last doctor's appointment. I think it was November 29th. All of the records show that he's been 90% or more percentile for weight. We submitted the declaration documents that show the last 3 years he's been 99% plus. It's not my client just all of a sudden, let's feed him candy and snacks all day. It's something that's ever since he's been one has had an issue with it. My client's the one who raises health issues when we have opposing party who doesn't. At that doctor's appointment, my client was the one who raised the hearing issue, not opposing party. My client brought that up to the doctor's appointment and got those tests set up. Versus opposing party who just recently last month had a doctor's or a dentist appointment set for the child. My client was waiting at the dentist asking where you were, and he's like, oh, oops, I forgot. He's not even off the bus yet. And then had to reschedule it because Stephen forgot about the doctor's appointment. She doesn't badger or harass the child for information. She engages in normal dialogue that one would engage with their child. How's your day? How's school? Etc. My client doesn't drink. My client doesn't use drugs. They submitted a TikTok video about lottery tickets from 3 years ago that she got as a gift, trying to demonstrate she has a gambling addiction. I got lottery tickets for Christmas. It doesn't mean I have a gambling addiction. Additionally, after my client received the pleadings, she went and independently took a hair follicle test. We submitted those records to the court to show that I don't use drugs. It was negative on everything they tested for. Regarding like the reading, my client is an active, avid participation with the child. Her concerns are when the child is at Stephen's house, the child can't progress to the next step or the next book until he achieves perfection. The child has expressed to my client that he is scared about doing the reading at dad's house because he has to be perfect. And if he's not perfect, he's scared of that. You know, my client has tried to address the reading issue, rebuffed by dad. My client tries to address school issues, rebuffed by dad. We've submitted those text messages. The majority of these issues stem from this protection order that is between Stephen's fiance and my client. And what dad's trying to do is make it appear like this is his protection order, that he's on the protection order. Brooke never asked for Stephen or Brody to be on the protection order, and Stephen and Brody are not on the protection order. Additionally, when they went to the modification hearing on May 31st, Judge Hayes indicated that a protection order should not have even been issued, as it significantly was going to impact my client's joint custody. My client obtained the audio from court for them. To state that things are now all of a sudden getting worse, which again is just blanket allegations. There's no dates, there's no times. So it's not like on this date she did this. So there's nothing showing that anything has happened since April 12th. It's just that, it's just stating it. One thing they're saying is my client is crazy and walks around the car at exchanges and she's not supposed to. But again, this protection order is not about Brody or Stephen, it's about Brooke. And she only has to stay in the car when Brooke's at a protection, or when Brooke's at the exchange. Brooke's been at one exchange. She's allowed to get out of her car at all the other exchanges. My client has not been to their home since March of this year. My client's never gone into their bedroom and stood and leered over them at night. And my client's not used any firearms or been violent with her. And again, we have to do a general denial of these because we don't have any corroborating evidence or any dates to do anything else. There are times that my client can't avoid driving by Stephen's work, but again, there is no protection order against Stephen. You know, it's a very small town. Her family owns a business. She wants to go to a certain grocery store. She can't help but drive by it. But again, there's nothing saying that she can't. My client only calls the police when Brooke has violated her own protection order. Regarding a few other allegations raised by Brooke, again, you look at the first two things that Brooks raises in her declaration. It's an allegation from 2019 and 2021. Again, issues that have already been addressed and decided upon prior to these orders being entered. Regarding the wrestling, and she doesn't want the child to be involved in wrestling. Of course she does. This protection order has put a kink in how my client can bring the child for practice, go to practices and games. So there takes a little bit more. So she definitely wants the child involved, but it might involve having to amend a protection order. So my client's not violating this every other week for games and practices. The child's not behind in school. There is an email from the teacher saying that he's good. He's ahead in the class. Regarding child support, opposing party didn't provide sufficient information to determine if there should be modification. He's provided one pay stub that is a month old when the RCW requires current pay stubs, more than one, in the last 2 years of tax returns, which he didn't do. They also didn't do a child support worksheet. They certainly could have done one based on minimum wage or whatever else they think that she makes. We did a financial summary. We took exactly what she makes, ran it through a year to date. Her average is $3,082. We did the same thing with opposing party, and we did his average of what his average is, and it's not $6,000 a month. His average gross is $94.53. I think actually Ms. Baldwin said that was net. And a side income, I have no idea where Ms. Baldwin gets $500, but we presented her pay for this year, and it shows for the travel that she made $373.92. That's $31.16 a month. So our request is that we deny the motion for adequate cause, leave the current parenting plan in place, deny the request for a GAL, but if the court does appoint one and it, with all of these allegations back and forth, it makes sense. We ask that Stephen, based on his income, pay 100%. We also ask that the parties utilize our family wizard, deny the request to modify child support, their request for fees, and we're requesting a $3,000 contribution. Thank you.
Rebuttal.
Thank you. Well, first, when you look, the first allegation is essentially, hey, none of this happened in 2023. Ignore all of this. It's all been resolved. But when you look at the declaration of Brooke Adams, she states, there have been instances where I discovered Lacey in my bedroom and my children and I have awakened to the unsettling sight of her watching us while we slept. This happened several times in 2023. So this idea that this is all old information, not accurate. The original filing for the modification was October of 2022. So that filing wouldn't have included any information from 2023 in that original filing. So again, we have instance after instance after instance that occurred in 2023 to the point where it required the entry of a protection order and then the increase and modification of that protection order. What they've provided from district court is in no way a transcript. And two, even if you read what they wrote, it's essentially the court saying, hey, this involves superior court matters. I'm going to send it to superior court because they have the right to do that. That's not saying that the order shouldn't have been entered. And then superior court entered an order, strengthened it, and extended it. So this idea of, oh, it should have been, not have been put in place, it's just false. It rings false and it is false. As to, you know, hey, again, nothing's happened. There are multiple incidences, multiple protection orders had to be put in place. Ms. Adams, my client's fiance, can't include this child on the protection order. She's not a parent of this child. That would be inappropriate. My client's trying to modify the parenting plan in part to create these boundaries. That was one of the reasons why he filed for the original modification, was to create boundaries in the hopes that that resolved some of these behaviors. It didn't. Some of them have gotten significantly worse over the last year, necessitating a full modification. Again, counsel tries to undermine, saying, hey, my client really doesn't have mental health issues. Her own declaration belies this, though. She says the level of stress this year, not this one time, this year has been insane. These are her own words. The vast majority of this case is proven by the petitioner's own words and own texts that she submits. Again, the risks and the domestic violence in her household. When we look at things like the child being able to participate in a physical activity that he needs, it's essentially, unless you drop the protection order, child isn't going to get to go. Unless you do what I want, child isn't going to get to go. That's abusive use of conflict. It's and in no way do you see in any of the materials as, hey, here's how we can work out transportation. It's just, I'm not getting what I want, so child will be the one to suffer, which again isn't appropriate. When we look at her pulling child out of school, she pulled child out of school to do a 29-hour drive for her mother's divorce. That is illogical and not in this child's best interests in any realm of thinking. So again, we have serious issues with domestic violence. We have the petitioner's live-in boyfriend remaining completely silent, which is a huge concern. We have protection order, an amended and increased protection order. We have child being pulled from school. We have child who has some pretty significant and increasing issues with weight and weight gain. And we have child with some behaviors that are markers of abuse and concern. And again, that child's being locked in a room. Anytime you're locking a child in a room, there's huge red flags. So given this, we believe our request is more than appropriate. Additionally, there's no question the court should appoint a guardian ad litem for this young child. And as far as child support goes, again, I can't guess at what the petitioner's income is now that we have it. $30 per hour at a full-time is how we got to the number I provided, plus $500. Again, that's what the gross number on that they provided is $498 in some sense. So $500 gross per month is reasonable for that second job. That's what you should base the child support figures off of. We're asking for that one.
So, Ms. Baldwin, I had one question in regard to, and I don't know if I missed it or what, and it has to do with the statements about the child and abuse, the black guy and those things. Is there a date somewhere?
I don't know that if the photos are dated or not. I know there was photos of them, but I don't know if they had a date or if the text messages had a date that included the year.
I didn't see the text messages having a date. I found that a problem in a number of these things that were submitted by both sides, that there's no date on text messages.
Your Honor, the date for the black guy was 12/23/22.
So that would have been after, so if it's 12/23/22, the original petition for modification was filed in October of 22.
All right. The other question I had is in March of 23, child support had mom's net at 2,856 and dad's at $5,891.90. And I'm trying to, obviously, some time has passed here, but it seems like a significant, I'm hearing significantly different figures.
Our figures, Your Honor, about the same for dad. We had dad netting about 58.46 and not mom netting 26.93. So ours are fairly similar to what, and we just used the actual pay stubs and did year-to-date calculations. So we're basically the same as prior.
So my client's income's based off of his year-to-date. They're using a gross and I'm using a net. So I don't think that my client is significantly different than it was previously. What they're doing for their client is she's making $30 per hour, but they're basically letting her work however much she wants. So they're dividing her year-to-date net or her year-to-date gross by 12. And I'm figuring her income by taking her hourly rate and multiplying by a full-time hourly rate. So I'm saying, hey, she makes $30 an hour times a 40-hour week times 4.23. That's what the court should impute as her gross. They're saying don't impute her at full-time. She can work sort of however, she can work part-time. So they want to use sort of a part-time amount of work for the child support figure. So I think that's the difference in the mother's income.
That's not actually, Your Honor, how we calculated it. It's divided by 12. We did a summary. We input it in. My client works 25 hours a week and goes to school full-time. So she can't go to school full-time and work full-time. So we literally said between this date and this date, you made X, put it in the calculator, and it told us, which is only $200 off from what child support has done. So basically our calculations are very similar to what child support's done.
We just don't have any information.
So Ms. Powers is present. They have filed an interest in child support. Ms. Powers?
Thanks, Your Honor. We actually just filed a declaration of state's interest in this case. The child is on state medical. So we'd ask whatever the court orders about child support that it include a provision identifying that the child is receiving public benefits through the mother.
No objection. We'll make sure that's included.
All right. So first off, I'm going to go through the objections. In regard to objections by the respondent, the declaration of Brenda Jackson, in consideration of that, I did not consider it. I couldn't figure out or see, the affidavit does not define how the person comes by the information. It talks about a number of things. So that declaration will be stricken. Declaration of Sarah Remmers, page 2, line 13 is stricken as hearsay. The information for temporary parenting plan, the court does find the document to be additional information added by Ms. Klopp in violation of the length of affidavits allowed and will not consider the additional explanations, but solely the parts that are that of essentially a proposed parenting plan. In regard to Exhibit 7, The declaration of Lacey Klopp, this is essentially a declaration of a parent teacher that is not a sworn affidavit, will not be considered, although essentially the court is not going to consider this document already as stated. As to the objections by the petitioner, the affidavit of the respondent, it was 7 pages, but 7th page is the oath and signature. I've not counted that previously, will not count it here, so that affidavit stands. The affidavit of Brooke Adams is 6 pages. This does exceed the page limit, and I stopped reading at 4 pages. So the last 2 pages are not considered. The affidavit of the petitioner, this is 4 pages, so I'm not sure where there's an issue. Thus, the even further additional affidavit of the petitioner, because of supposed length of respondents, will not be allowed. And I don't know if I just twisted those. So all that said, about the timing of the petition, in looking at the modification of the parenting plan or decree under 2609-260, except as otherwise provided in 4, 5, 6, 8, and 10 of this section, the court shall not modify a prior custody decree or a parenting plan unless it finds, upon the basis of facts that have arisen since the prior decree or plan, or that were unknown to the court at the time of the prior decree or plan, that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child and is necessary to serve the best interests of the child. And then there's more in regard to military duty. But so my question, Ms. Baldwin, is you're going from the filing of the petition, and it appears that it seems that once that parenting plan was entered in April of 23, that would be the date. So I'm just curious what you're looking at.
No. So per statute, the date that you would look at is the last final parenting plan, and that was April of 2020. So all of the facts that have arisen since 2020 are relevant. Counsel repeatedly argues that hey, you shouldn't consider anything because essentially the case has gone quiet for the last year, so nothing's really all that bad. So that's why I was being clear, like, no, this is a situation where things are continuing to spiral out of control. But the statute's very clear. You go from the last final parenting plan, not the current temporary parenting plan. So my client sought.
Okay, I was mistaking something there. Okay,
no problem.
Apologize. Okay, Ms. Jocelyn.
Yes, Your Honor. The issue that we have with the parenting plan is that it should go from April 2023 forward. All of these things were considered in effect. Had they been raised or not considered, they would have been reflected in a plan. Why would Ms. Baldwin have a temporary plan entered in March and then April that said no 191s and no restrictions, keeping both of these plans, the 20 plan and both of the 2023s at 50-50? We have to go with what has happened since April. If any of this was relevant or affected, it would have changed the plan in March. It would have changed the plan in April. You don't get to relitigate issues that were already brought up and decided because we had all of this plan. We have from 2020 until 2023. We took all that information and then in March 2023 had a new plan that was entered. So what we need to do is go from April 12th, 2023 forward.
So now that I have it clarified, for some reason I read it that a final had been entered and I didn't relook at it to verify. So I misread what had been stated. So with that, then it would go from what Ms. Baldwin has indicated. That said, in regard to the overall and looking at this and weighing all the evidence, and to make it very clear, I did read everything other than what I indicated and reviewed the files and records. So although I may be short in what I ultimately state here, that I did review everything and I want to make sure the parties are aware of that. I take it very seriously, and obviously this is about the best interests of a child and what's going to happen from here. In looking overall at what the court has significant concerns about has to do with the protection order and what occurred there. There's some pretty concerning behavior, and I agree with what Ms. Baldwin had indicated in regard to what had happened by the district court judge, is that they don't tend to like to handle things that impact and affect a superior court matter. So they transfer. It's not unusual. It's something we see on a regular basis because they know the impact of what they do is going to be significant on an effect on another case. But it's the behavior that's extremely concerning. One in which the court does question the mental health and does question the behavior of the mother and what's gone on there. So that's of significant concerns there. The child safety and domestic violence. Again, the court does find that significantly concerning. And that it is within the time frame that we've been talking about, and one that brings the court great pause to try to figure out what it is that is going on in regard to that child. What
And,
has
Your Honor,
or hasn't occurred.
I apologize, Your Honor, and I understand you're going off that, but when we look at the RCW, doesn't say final parenting plan, and this is significant whether we're looking at 2020 versus 2023. There's nothing in that RCW that says final. It says parenting plan. So my concern, I wouldn't normally interrupt, Your Honor, but my concern is we're making a ruling off that when it's not final.
Okay. I've made my decision. I'm going off of what Ms. Baldwin has indicated. Please don't interrupt again. So in regard to the allegations and the statements that have been made, the court has significant concerns. And in regard to the criminal history, understanding that it is older and the content does give the court concern. So looking at the dates and that, and then weighing that with what else has occurred creates an issue of concern. Instability, there are lots of reasons people leave jobs. I'm not making that a big issue of concern as far as that goes. The neglect of child's health care, this appears to be something that's been an issue for some time. Is it another possible concern that needs to be addressed? Probably for, not probably, but it should be for the best interest of the child. Do I weigh that as being the big factor here? No. Mental health, as I said, looking at what's gone on in regard to the restraining order and the basis for the restraining order, that is of significant concern, as I already indicated. Addiction, the court doesn't see significant basis in regard to that part of it. The hair follicle test was provided, and so no, there's nothing there that is supported as far as that part of it goes. Schooling, the court always has concerns when a child makes decisions to pull a child from school for this or that. Sometimes it's something that can happen and needs to happen, but there is concern that this is occurring as often as it is. The wrestling, when a flat out denial is made, that's something that I think could be addressed one way or the other. And although it's of concern, it's not a major issue here. Overall, the major issues that I'm looking at are what the court finds of concern is the behavior as it relates to the basis for the restraining order and the mental health that comes with that, and the what appears to be, and the court can't make a finding at this point that it has to be I apologize, I didn't write his name down. The particular individual, but it's the overall looking at what's going on in mom's home that's of great concern. So at this point, the court does find there is adequate cause to proceed forward. This is an adequate cause hearing, so the court does find the basis to proceed forward. The showing has been made. And then in regard to what needs to occur pending a final decision of what may or may not happen. The court does believe that a guardian ad litem is appropriate and that the question, do I use these three same names or what do I? Okay.
Will be Amy Turnbull, Beth Fellows, and Karen Lawrence.
All right, so the three names are Amy Turnbull, Beth Fellows, and Karen Lawrence. Miss Baldwin, do you strike any of those?
I'll strike Karen Lawrence.
Okay. Miss Jocelyn, do you strike any of those?
We'll strike Miss Fellows.
And that leaves Amy Turnbull. Amy Turnbull will be appointed as the guardian ad litem. What I'm going to do in regard to the guardian ad litem is in regard to, I'm going to make this 50-50 at this point. That can be reconsidered and re-looked at later on. And in regard to the pay at this point, understanding I will be looking at child support a little bit differently than I am in regard to the guardian ad litem. But in regard to the father, that will be private pay. In regard to the mother, I'm going to make that county pay. Once she was determined to receive state benefits, I think that's only appropriate. Then the standard dates need to be included.
Does Your Honor want a 30-day? So there is, you can include a 30-day check-in to make sure they've paid their fees, but I don't find that necessary. Okay.
No. So pending a guardian ad litem report, the court is looking at currently a 50-50 plan. And a plan such as that is one where parties can communicate, parties can get along, and looking at the issues again that are great concern at this point that I have in regard to the mother, again, being the basis for the restraining order and the mental health of where mom is at this point, the concern as to the safety of the child. That based on that, I am going to be looking at what I would call more of a standard type of schedule at this point, where mom where the child will live primarily with the father, and the mother will have the child the first, third, and alternating fifth weekends of the month. Fridays shall define the weekend. Ms. Jocelyn, you indicated your client is going to school. Do you know what time on Fridays maybe she is available?
She is on, she can, oh, she's remote school, so anytime is fine, so she could do an after school.
Okay. Child's going to what school? Remind me.
I don't know the school. I know it's in Castle Rock School District.
Castle Rock Elementary
Castle
School.
Rock. Okay.
There's just
All right. So mom can pick up the child from school on her weekends. And then on Sundays, remind me where the exchange has been at this point.
they're doing the exchanges at the Park and Ride. It's in my, I believe it's in my proposed parenting plan.
Castle Rock
Yeah.
Park and Ride.
All right, so that'll be where the exchange will be on Sundays at 5 p.m. For now, the father shall have sole decision-making. Any dispute will need to come to court. Standard holidays alternating. So really getting to a standard plan at this point until we have input from the guideline, with one condition is that I do not want the child to be unsupervised with Mr. Mitchell. And again, although I don't have a major concern in regard to drugs, the mother shall not consume non-prescribed drugs. I don't think that's an issue. Is there anything else in regard to the parenting plan that you need to know?
I don't think so.
Right. In regard to child support, I'm not going to deviate a whole lot from what was just ordered as the figures for the parents' incomes. Do I think maybe it could change? Possibly, yes. But at this time, for temporary child support, it'll be refigured, but using the figures that I talked about of $2,856 for mom and $5,891 for dad.
Very good. And then the court will just have us keep everything else essentially from that last support order in place, like tax return. Claiming the child, just maintain what's there.
Maintain what's there.
Okay. I think that answers all my questions. Presentation in 2 weeks.
That's fine. Jocelyn, any questions? Anything else?
Yes.
No, Your Honor, the only thing we had asked for is the parties to utilize our family wizard.
That'd
No
be
objection.
appropriate.
Yeah, I would just ask each party pays their own fee, so it's kind of clear.
Okay, anything else?
Nope, I think that puts our presentation on the 16th.
Okay. All right. That concludes this matter. Clop v. Clop 19-3-00361-08, presentation of order. Who do I have present?
Thank you. I'm Lucy Baldwin. I represent Stephen Klopp, the respondent. So in this matter, my concern is that although we served and filed the orders timely, the objections were received yesterday on the holiday at 9 p.m. My guess is Your Honor doesn't have them. They certainly aren't in Odyssey. My guess is that they haven't even been filed since they were served to me on yesterday at 9 o'clock at night. So has Your Honor had a chance to review those objections?
I have not, and I will tell you, I'm not very happy about what's happened. I was here yesterday working on the files. Even if it had been filed yesterday, it would not have hit Odyssey. And so to get it at 9:15, I think is when it arrived in my email. There's no way I'm going to have the opportunity to see it, review it, and have this done for today, which I see that as a delayed tactic, and I don't appreciate it.
So here's my requested relief. I think it's either the court can just ignore the objections and enter the orders as is, or in lieu of that, I believe we don't have docket next week due to the judges being in a conference, if I'm correct. So that would take us to the 30th. The 30th is fine, but I'd ask for terms of an hour of my time, which we're basically at today for when I started logging on. My hourly rate's $5.25. So I would just ask for terms of an hour over and then over to the next available docket. Or you could put us to a presentation docket, whatever's more convenient for Your Honor.
And if we can be heard, Your Honor.
Just a minute, 29th and 30th is when we're not having dockets. So the 23rd is actually open.
Okay, very good. 23rd is fine.
Ms. Joslin?
Yes, Your Honor, this wasn't a delay tactic. We asked Ms. Baldwin twice if she wanted to set it over. She certainly could have said yes. Ms. Baldwin, knowing that there was a holiday, didn't give us any additional time. She served it to us Tuesday afternoon, which gave us less than 3 days to respond. We would have had to review it, respond, and had it done by Friday. And so had she done it sooner, we would have had more time. She had more than a week to do it. We did it as soon as we could. I was waiting for my client to review as well. It's not our intention to delay it, which is why we've asked twice if she wants to set it over. Ms. Baldwin certainly didn't have to sit here for the last hour. Again, to us, that is games played to trying to get attorney's fees. We're not trying to short-sight anybody, but she also should have served us the proposed order sooner, knowing that there was a holiday. It's inequitable to allow her 7 days to prepare them and us less than 3 days to review them. So we're certainly fine with the set over. We said that in the email. We're not trying to delay any games. There was a bunch of things in the order that she changed that wasn't ruled upon, so that's why it was very lengthy.
Your Honor, I apologize, Your Honor, if I may address the court.
Go ahead.
On behalf of the state, we did not receive a copy of the orders, and so we haven't had a chance to review them. I know that Ms. Powers had requested medical language, so we haven't had a chance to review to see whether that was entered in the child support order.
We sent our proposed changes to Ms. Powers. I did not see Ms. Baldwin send it to the state on the email that came over to us.
Ms. Powers is no longer with the state.
Right. And I'll just note, I don't see, I've looked for Ms. Joslin and the case name. I don't see any emails until the objection came across my desk. So yeah, so that is what it is. Maybe it was sent with from a different person or with a different case name put on it, but I'm not seeing that. Up to Your Honor. Again, we served them on Tuesday. There was plenty of time. We are where we are.
Less than 3 days when they had a week is not equitable.
You're repeating yourself, Ms. Joslin. All right. At this point, there was a holiday. I get that. I don't understand why 3 days wouldn't have been enough, but so be it. At this point, there's no way I'm going to get through it with the state not receiving anything. For that reason and that reason only, I'm going to go ahead and set this over 1 week and make sure to get that to the state so that they can make their objections. I won't grant any terms at this point, but at for future, please don't assume that we don't work on holidays. We do. So, okay.
All right, very good, over 1 week. Thank you.
I just want to quickly address number 5 on the docket to make sure where we're at with this. Unfortunately, I had sent an email to the incorrect email from Ms. Baldwin, so I expect she may not have seen it. And
So we're actually in a good place to go forward.
Okay.
Ms. Winkles and I were able to work together to resolve 99% of the problems. We have a couple issues to address on the parenting plan. That's it. And so you should have a packet before you of orders. I just want to make sure that the cover sheet to the orders has today's date on it, because I did revise them. And then those are the orders that Ms. Looney signed off on as well.
okay, orders that were received January 10th, so that would not be, I have that's the amended objections. Not quite sure how these got back here. I don't think those went through the clerk. Let me look at another file here. So I have another set of orders, and let's see.
And those might be my orders, so just make sure that they're, because we also sent in orders.
There are Miss Baldwin's orders.
Perfect.
But let me.
And the cover sheet would just have today's date for presentation.
These went through the clerk's office, and there's no cover sheet is the problem.
If you look at the order of child support,
that's what I'm getting to.
it would be it would have Ms. Looney's signature on it.
All right. There we go. Yes, I have Miss Looney's signature.
And that's the right packet. All right.
And then do you also have our packet of proposed orders?
I do not in that file. When did you submit them?
That would have been when the ice melted around town. So it would either been Thursday or Friday, whenever the court was reopened that day.
I do not have. I just have your amended objection to proposed orders.
Okay, they were filed the same day.
Okay, they're not in my, I call my clerk file, which are the orders that would have been submitted. So I'm not sure where that is. Do you have any other orders?
I do not have any other orders. There were things tweeted by Erin.
It would have been last week. I actually went to the court myself to do it.
Okay.
The proposed orders and the objections were filed on the 18th.
Okay, so if they were titled proposed orders, then they got filed.
And then I did another one directly to the court. So I had the proposed with the cover sheet that would have said, original on the cover sheet. And then there would have been a second copy below that said original on the actual pleadings.
I'm not questioning that you did that. Unfortunately, I don't have them.
And I still think we can go forward. I'm the moving party. It's my job to draft the orders. Ms. Winkles is the objecting party. So she makes her objections and we go from there. So when we look at the order of child support, which I presume is what's before you, we agree to make one change. If you look at page 2 of that order, Ms. Winkles is just asking that at section 5, did you just want that second box under net income just struck, Ms. Winkles?
So the box that says that that none of this is overtime, That's it. Essentially saying that, yes, overtime's included. That wasn't in the original order. So I'm just requesting that it say no, that overtime's not included in this order for either of them.
That's fine. You can either write no or strike that section entirely. It's a temporary order.
Okay, I want to make sure under parents' income, paragraph 5, page 2 of the order, I have net monthly income 5891. This income is his parents' actual income.
No, but only as to mother.
Well, and I would disagree with that because the original order, which I'm
Okay.
looking at right now.
I'm just trying to make sure I'm adding what you want in the correct place. And you want me to add does not include overtime, correct?
That's fine.
Yeah, under section 5 or paragraph 5, where it says, does this parent have income or overtime from a second job? In the original order, which is the exhibit B, I believe, of my amended objection, it says no. Both of them say no.
Okay. So I see this now. Does this parent have income from overtime or a second job? And no. Okay.
I think with that change, you can sign the order.
Okay. Ms. Winkles, you agree?
I agree with that.
And are you okay to put approved via Zoom?
Absolutely.
Okay, I put approved via Zoom and I have signed off on the child support order. So I will also sign off on the worksheets.
Very good.
Okay.
So next,
I was just going to say the adequate cause order, we have no objections to, and we're okay with signing via Zoom.
Okay, signing that order, putting approved via Zoom. Okay, thank you.
and we do, so in this case, we're appointing Ms. Turnbull, who is here. Ms. Winkles is asking for an interim review. The court didn't order that, but I'm not objecting to that. I don't know if Ms. Turnbull wants to chime in on kind of her thoughts on how much time she would like for that.
Turnbull?
Yes, not being familiar with the case, I'm not sure how much there is to investigate here. Perhaps you could give me some guidance and I will take your advice.
I would, after reviewing all the pleadings and everything, I would say it would be appropriate.
Okay, I will take that.
And we were thinking of somewhere in March. I believe May is the final review that we have. March would be about 60 days. That seems fair.
Okay, I will take your advice.
And that's fine.
So I'll add prior, just above the final GL report review, I'll put interim review.
I'm going to do the 26th for a date
of March.
Yes.
I'm out of town that week.
Oh, that's right.
Actually, for 2 weeks.
That's right. We had that same issue. Either 1 week before or 2 weeks after. Do you have a preference, Ms. Turnbull?
Either way works fine with me.
All right, let's do March 19th if that works for everyone else.
And that works for me.
Okay. Adding March 19, 2024. I'm changing and I'm putting at 9 a.m.
Oh, and that should be at 1 a.m. Sorry. Yep.
Yeah.
Thank you.
And then May 14, 2024 at 9 a.m.
Thank you.
Okay, is that all that needs changed there?
That's my understanding, yes.
Yes, that's it.
Thank you, Ms. Turnbull.
Thank you.
Putting approved via Zoom for Ms. Winkles.
And that's fine.
Okay, so that leaves the final, the amended temporary parenting plan.
That's correct. So
And-
I think the easiest way to go through that is to just look at page 2 of opposing counsel's objections and just kind of go through those one at a time. She kind of
actually
lays
like-
those out by section.
Since they're my objections, I'd actually like to go through the sections because there's additional language here added. If you look at page 1 of my objection.
Hold on just 1 second.
Yeah.
I need to make sure I initial something that I didn't. All right, looking at temporary parenting plan 1A. Go ahead, Ms. Winkles.
Yeah, so we've got the first page, and under abandonment, either it should say obviously neither parent has any of these problems. Under B, obviously, it should be emotional, physical problem and neglect. Those were reserved pending the GAL report, as you stated. We've actually included the transcripts from that here, and we also got the CD. They're rough transcripts. They've not been transcribed by somebody with skill to do that, but they are there just to assist us here. The issue we have are sections 4, 5, and 12, and I'll go through section 4. There's limitations imposed. Your Honor stated that you didn't have enough information, that you were concerned with mother's mental health, but that you were really wanting you wanted the GAL to be involved. You can't have limitations with having reserved under findings. So you don't get one and not the other. You can't have limitations if you have no findings. The findings are reserved. So we'd ask that any of the limitations under section 4 be stricken. That section should also be reserved. So section 3B should say reserved. Section 4 should say reserved. Under decision making, we should have school and healthcare. Those should be with dad, and everything else under there reserved. Reasons for limitations.
Okay,
Again,
let's go through this bit by bit so I can make changes as necessary. So under paragraph 4, Ms. Baldwin.
So 3B is reserved. Under section 4, the court can put in limits. In this case, the court said it does have serious concerns for the safety of the child, and these are orders that the court made, that she needed to abide by the anti-harassment order, and that the child was not to have unsupervised time with the mother's boyfriend who presented a domestic violence risk. The court specifically made that order. So to just say, I'll just strike that off, that's not appropriate. The court made that specific order for the safety of the child. This is an appropriate place to put it because, again, some of the concerns here warrant that, and the level of concern warrants putting it here. Does the court want to stop at just section 4?
Yeah, I do.
And this is better for section 14 in that the court stated, and you'll see again, the transcripts under my objections are there. The court stated they had concerns, but that they had no information. And this was the problem, to impose a limitation without information. It is a safety mechanism in the court, absolutely, to not have this person that hasn't been vetted by the GAL yet, to have, these mental health allegations. The court will remember a lot of these.
Let's not re-argue.
Okay.
Hold on. We don't have time to re-argue. If we are going to do that, I'm going to stop. I'm going to take the other cases. And so I heard argument. I get it. I know what you're talking about. And I agree that I don't necessarily say that you can't put limitations on a parent just because you don't make certain findings, but I don't have a problem, honestly, with either place. They are things that are supposed to be done, but I have no problem putting them under paragraph 14. They still apply. And I haven't made any basis, so those can get moved to paragraph 14. And then just put reserved under 4.
Okay.
All right, so I know about the religious upbringing part and the extracurricular activities. Let's address the religious upbringing part in regard to
so the religious upbringing, this is just a constitutional statement, and honestly, Ms. Winkles has an almost identical statement in her section 14. This is immaterial.
Yeah, that one,
as
that one's not the concern. It's the healthcare part that was the concern.
the healthcare part is actually is the vast majority of that mirrors the restraining order that is that although the court will have to dig deep into Odyssey. We did attach it to my client's declaration, but there's a huge section that is part of their restraining order that talks about a medical emergency is where a child's airway is observably. So like all of that pieces are there. So a big section of this is part of the restraining order already. So we just copied and pasted a big section of this. The father being authorized to make healthcare appointments is basically already stated because the father is the decision maker. We're essentially allowing and making it clear how the mother is going to be involved. We're including the mother in a reasonable way and kind of detailing how that's going to happen. That's not a bad thing. That's a good thing in a high conflict case to detail out how specifically that's going to happen. And this was in my proposed order. This is not new. This was in my proposed order.
Ms. Winkles?
Yeah, my concern is this was never litigated in that last hearing. It was not talked about or argued by both sides. There is a current restraining order, which is in place for this very reason. We don't need that language copied, and the word majority of concerns me because it means it wasn't just copied word for word. We have additional words in here that weren't included in the restraining order. If the restraining order is in place, why does this need to be in this order at all, especially when it wasn't litigated? That order still controls, that order is still in place. Nobody's changed that order. Additionally, that order is between my client and wife or fiance. I can't remember, Mr. Klopp. It's not between Mr. Klopp and my client. It's not between child and my client. The only one restrained is the wife, girlfriend of Mr. Klopp, or the protected, I should say. It doesn't make sense to put it back in here when it wasn't argued and it wasn't ordered.
So unfortunately, that's not true. A bunch of the other children that are my client's children are also protected parties. So those children are in the household, they're in the cars. And we also don't want situations where, oh, that restraining order fell off and now it's sort of a free-for-all.
So in regard to these paragraphs, understanding looking at the conflict that was going on between these parties and determining what's in the best interest of the children or child in regard to the healthcare part of it, the last place we want is for that conflict to be an issue. And so I am going to leave this in.
So moving to 8 then in that case, which was just essentially when it applies, yeah. The weekends should be defined by the Fridays in the month, not the first Friday. Just the amount of Fridays, I think it's just a word. It should be defined by Fridays in the month, not the first Friday of the month, if that makes sense.
And I adamantly disagree because the first Friday of the month is how you count. So if it's the first, third, and alternating fifth, then the first Friday is how you then count. So mom doesn't get to decide which one is the first. This is the first Friday, and that's how you count the Fridays. So I guess it is a distinction, but it has a difference. And so it's just how you look at the calendaring.
So in regard to this, I've always gone off the first Friday of the month. It's defined by the first Friday of the month. So it will remain as I can't even find the language. Oh, here we are.
Yeah.
I see it. That will remain.
Okay.
All right. Holiday schedule.
Well, under that same section, if there's no school, transfer time should be the same time school lets out. We have it much later than even the Sunday transfer. If there's not going to be school, it should be 3 p.m. if no school, because that's the time mom was originally getting them. Why is it suddenly later if there's no school?
And that's to accommodate work schedules, because if mom's picking up directly from school, my client doesn't need to transport anywhere. But if it's a non-school day, then we need to have a transporter. And so sometimes that means somebody has to be off.
And then that limits my client's time who's stay at home while she's working from home, and Mr. Klopp is off on Fridays.
I'm sorry, where are you looking? I'm not.
Line's about 8, 9.
Yeah.
So she's looking at There's a paren right at the end. It says every first
Oh,
third, and then there's a paren or 6 p.m. if no school. So it's just what time if no school.
And neither party works on Friday. So it makes sense to have the 3 p.m. trade-off rather than waiting hours, because she would normally get the children at school at the end of school.
okay. All right, in regard to that, actually what I tend to do is actually go in the morning, but if neither of them working, it can be 3 p.m.
Very good.
Under section 12, oh wait, the holiday schedule, my apologies, section 10. If you look at that schedule, it's overly biased towards the parent with the majority of visitation. You'll see the even odd years are not followed. Typically, these parents have exchanged the split spring break in half. It should still be that way. We also have 4th of July. My client doesn't want that, but what my client does want is to see the child on Christmas Day. My client would like to have Thanksgiving, since she used to be 50-50 and now we've restrained her so much back. These are coming up quickly, especially spring break. I'm not as concerned with Thanksgiving or Christmas at this point, but spring break is coming up, and it makes sense that they split in half with the exchange at 12 on Wednesday.
I maintained them from the last order. So the complaint is I want to rewrite them, but I'm looking back at the March 2023 order, and these are what they were.
And
So
that's when they both had 50-50.
Right. So I don't think that that's reasonable to say, well, now I want to rewrite this. I didn't argue this at the time.
So this is a temporary order. It's going to remain as written here.
Easter is not in this order at all, though. Is that something we can take care of rather than come back on at least Easter?
I'll take no position. Your client's call or your honor's call.
Easter, well, Easter tends to go with spring break.
It does, and it does this year.
So if it's not a part of the spring break, I have no problem adding it, and you can do an amended or something to get it to me so it fits in. But yeah, do you know which it is, at the beginning or the end of spring break?
I think it's at the end of spring break this year.
Okay, so it would go to mom.
Okay.
Okay, that'll stand.
Okay.
Okay, anything else?
Section 12, the transportation should just say park and ride. None of the other was argued. Again, we're putting an order from a restraining order, which is in place and still current. It's not going to fall off between now and the end of trial. It's a good order, and it can be renewed quite easily. It just needs to say park and ride. That's what the court ordered. That's what's in the transcripts. Transportation's at the park and ride.
So so 2 things. The restraining order is set to expire in 2024. We do want these provisions to remain. 2, the restraining order protects specifically my client's children as well as his significant other. But we don't want the game to be played that if it's just him in the car, then all the rules are off and we can play this game. So again, we should have sort of the same rules, whether it's just my client in the car or him and the kids or him and his spouse. The rules should be the same. It should be incorporated into this order. That's reasonable.
And Your Honor, they attempted to get that protection order and it was denied. So to then essentially have it without argument now put into this order seems manifestly unfair. They attempted to get dad protected, and now they're going to get him protected without the benefit of having a hearing when it was denied in court previously. That seems really unfair.
Didn't I rule park and ride?
That's what you ruled. It's on the transcripts.
Okay, then it just needs to be park and ride. So you're going to have to get me a new order because I'm not going to.
Sure.
Okay.
Section 14H, it says the telephone privileges are from age 10. I've never seen an order limit a year. It usually says telephone privileges for the child. It doesn't give an age. What this does is this child's 6. It means that there's no telephone privileges with mom for 4 years. It seems an arbitrary number that was chosen. It's not in the original. We would just ask that telephone privileges are from now. He can call mom can call a child. It makes sense that way rather than suddenly picking some arbitrary number out of the air that wasn't argued.
This wasn't argued and it wasn't ordered and it wasn't discussed. This is a high conflict case. What we don't want is then mothers calling child 10 times a day, fathers calling child in mother's household. The idea is at 10, a child is able to sort of manage some of those communications on his own. At 6, he's not able to. They're basically all have to be facilitated by a parent. I'm
going to stop this. I have other cases I need to get to. So at this point, what I'm going to do is reserve on this because I'd like input from the guardian ad litem.
Okay. So I would just ask, just go ahead
So
and
I'm going to leave it at this for the moment. And then I
Okay.
want input from the guardian ad litem.
Can we also reserve on 14J in that case? That was just separate parent-teacher conferences. Can we just reserve for the GAL? I doubt there's any coming up at this point anyway.
It's a little odd. The court can't force my client to do a joint parent-teacher conference.
No, I don't think I can. I think they have that right, and that's up to the school to set them up.
Right.
And I think the school would want with these 2 parents to have separate conferences anyhow.
I agree.
All right. So give me a new order.
Okay. Very good.
All right. Thank you, Your Honor.
All right. Thank you.
The next 3 hearings were continued, March 19th, March 26th, and April 9th. I didn't include them because they didn't talk about anything but scheduling.
0361-08.
That matter's ready, and I have a couple of preliminary issues I want to address.
Go ahead.
Thank you. For the record, I'm Chelsea Baldwin, and I represent Stephen Klopp. There was a declaration of Lacey Klopp that was filed, and it contains a significant amount of hearsay or statements for which there's just simply no foundation, and I'd like to go through those with the court and have the court make some rulings on those.
Hold on just a second. Are we talking about the, well, let me see. My computer's going really slow. Just a second.
No problem.
We're talking about the one that was filed on April 10?
I believe so. The first paragraph starts, I've submitted the required paperwork.
Okay. Yeah, that's what I'm looking at.
Okay, very good. So page 1, the second paragraph at lines 21 and 22, there's a claim that the child's bedwetting in my client's home. There's just simply no foundation for that statement. She's not in my client's home, doesn't make any statements that she is.
Ms. Winkles?
Yes, my client states that she was informed that by Mr., and I believe there's text messages that support that.
It's not anywhere in this declaration.
I believe it was previously filed with the court or is in the medical. It may actually be in the medical statements. I believe both parents took the child to the doctor because of that issue. But I'll defer to Your Honor.
Okay. At this point, I'll strike it. I without knowing exactly where it's. You know, and ultimately, I will tell you when I read this, I will go through this, but a lot of this I took as hearsay as indicated. But let's go ahead.
So same page, just down on paragraph 3, the statement that the child's teacher is good friends. Again, no foundation for this statement, no evidence that supports it.
Ms. Winkles?
Yes, Your Honor. If you'll notice, the child's the teacher's supervisor is a family relation, has a family relationship with the stepmother, or I believe the father's girlfriend, is I'm calling her stepmother in this case, the supervisor of that person. And my client believes and alleges that due to that relationship with the supervisor directly to the stepmother, that they are friends, and considering the district's policy, it also makes sense. So it's not hearsay, because there's no out of court statement that my client's relying on. That's not what it is. It's an allegation from my client.
So the statements, it's not hearsay is an allegation. There's no foundation. And it's sort of like, hey, maybe these people are related because they have the same last names. That doesn't make the underlying teacher a friend. And there's no statement of foundation otherwise.
I'm not going to strike it. I'll take it for the weight that it has, which I can only include as an assumption, because I don't see any foundation.
At page 4, at paragraph 17, and it's actually line 17 as well. So again, no foundation for the statement that respondent has changed the dates on the 911 calls. Doesn't provide any foundation for this. We're happy to file the CAD logs. There wasn't time to do that here, but again, no foundation.
We did file the CAD logs and sent it to everybody involved, including the court. So we received the entire CAD report and filed it with the court and also gave it to Ms. Baldwin. So those dates are incorrect. The CAD report should be with Your Honor, and I can check and see if it was actually scanned into Odyssey, but it was filed on, I believe it was filed on Friday.
April 12th, it's filed. So I'm sorry, Ms. Baldwin, anything else?
No, nothing, no further argument on that piece.
Okay. Ms. Winkles, anything further on that?
No, Your Honor.
Let's see, get back to where this was.
Oh, I have further evidentiary objections though, when you're ready.
So the issue as far as the respondent has changed the dates on the 911 calls. Let's just address that line. Ms. Baldwin, can you address that particular one?
Yeah, my client didn't. So we're just saying that there wasn't foundation. At the time she wrote this statement, there wasn't the access to the CAD logs. She doesn't indicate that she's looked at the, I will have CAD reports at the hearing. So she's not saying I've looked at them and I've verified that I have them in hand. She's just saying I disagree. But again, no foundation to actually say that she has the ability to verify when she's writing this declaration.
And if I can answer, Your Honor, she's the one who called 911 or called the police. It wasn't 911 in that case, but she's the one who called, so she should know which date she called on. So that's her personal knowledge of what she saw, did, said, and on the date she did it.
Well, I'll go ahead and allow it in the sense of I have a CAD report, so that by itself speaks for itself.
Next one is page 5 at paragraph, let's see, I believe as for paragraph 20. So paragraph 20, line 11. So claims that my client is paddling the child and continues to do so. Again, not in his home, no foundation.
Ms. Winkles?
Yes, Your Honor. My client supplied a text message where the father is actually talking about paddling the child, and then Ms. Baldwin also submitted the text message from my client about paddling the child. So I believe that they both use corporate punishment or have used corporate punishment in their house. My client's alleging that she spoke to the father. That's where the foundation comes from. Testimony. Mr. is a party to the case and can easily deny that. That would be the foundation.
So the text messages that my client provides are the mother discussing her paddling the child because the child essentially won't do what the boyfriend wants or won't apologize to her boyfriend. So those are the text messages that we submit. I don't believe that the text messages that mother submits indicate that my client is currently paddling the child, which is the specific statement I'm discussing. And hey, Mr. said, and there's no indications of that. These are people who have restraining orders. These are people that obviously are not communicating freely. So this idea that, oh, well, he told me, I think that A, it's not in the declaration, and B, it's very not likely.
So I'm going to strike that unless she's there in the home. There's nothing to confirm, and paddling can be interpreted differently, meaning paddling can be simply spanking a child on the bottom. And sometimes it can be while using a paddle. So it's a term of art, or not a term of art, but a term that can be read different ways.
And then same page at paragraph 21. So really the vast majority of paragraph 21 is hearsay. Child tells me that they're saying all of these things. So this is just pure child hearsay. But my client would absolutely deny that these statements are being made. But again, mother saying, oh, father's just saying these things. It's all just really rampant hearsay and child hearsay. That is not appropriate.
Ms. Winkles?
And I don't have the exact paragraph in front of me. Is there a way, can Miss Baldwin read it?
Paragraph 21.
I have the wrong thing up again. My apologies. Can you read that first line of that?
I am increasingly concerned.
Paragraph 21. Which line was that? I'm sorry.
Line 14, 15.
And Your Honor can strike that. I think the pictures of the child and the injuries that were happening in Dad's house are enough. I can argue that without needing to argue anything the child said.
And that'll be stricken.
And then at paragraph 22, it starts with that same statement, child's wetting the bed in father's home. It's the same argument. She's not there.
And I believe Your Honor already ruled on that.
Yeah, I've already ruled.
So with that, I'm ready to proceed to argument when you're ready, Your Honor.
Okay, let's go ahead.
So in this case, obviously there's a lot of information on both sides. But I think what's frankly should be most compelling is there's one truly neutral witness, and that's the child's teacher. And I often say that children's educational lives are a good barometer for how a child is doing. When children are doing, especially around children, when young children are doing well in school, it generally means that things are going well at home because they're able to sit down, they're able to focus, they're able to get through their school day and do well. As a barometer. And so in this case, child's teacher reports that child is thriving. Child is thriving on the consistency that he now has in father's household and that he's doing amazing. This is the teacher's report. And that changing his schedule now would likely throw him off, and that she hopes that doesn't happen to him. And so that's the neutral observer that sees that child Monday through Friday, 8:30 to 3:30, every day. And so that is the person that I think sort of best tells the story about what this child needs and what's best for this child. And it's very telling what the mother's reaction to this brief report. This report does not slam mother. It doesn't say mother's horrible or some awful monster. But what is mother's reaction? Mother's reaction is not rational. She then goes and files a formal report trying to get the teacher in trouble for this email, and is proud of it. She's proud that she's gotten the teacher in trouble. And she says that in her declaration. She says, look at this. I made this report. I sent these emails and I said how dastardly this was that this teacher advocated for this young child. And that in and of itself tells you a lot. She has now tried to blockade and effectively, to some degree, has blockaded that witness from the future. It's likely that now, because you can see even the emails that they submitted, which are hearsay, but nonetheless, I let them in because I think that they're important for the court to see. It's now going to require us to subpoena that teacher and the school district to be able to get those records. We're probably going to have to depose the teacher instead of just talk to the teacher to be able to get that information because of how aggressive mother is to a simple email like this. And that is the inherent things that we're talking about in this case, is mother's behavior and how it impacts this child. When we look at the mental health records that are submitted in this case, my client argues that he was not allowed to provide input regarding the domestic violence relationship. That if that was specifically like, nope, we're not going to take that information from you. And nowhere in the report does it indicate that that information was taken from him and considered. This is a 5-year domestic violence relationship. That is significant to your mental health. But even so, that whole piece of somebody's mental health being set aside entirely, we still have findings that are very concerning. The findings here are that there is a dysfunction in role performance. The report itself says dysfunction in role performance. Yes. Risk of deterioration. Yes. So this, in and of itself, we have this mental health report that does not say she is okay, and in fact says she is not okay and needs treatment. And then you turn and look at the treatment records. The treatment records that they submit, sort of saying, hey, look, everything's fine. Delve a little closer. If you look closer into those records, record after record after record says no progress, that she, in fact, isn't making progress. She isn't resolving the dysfunction. She isn't improving on the risk of deterioration. And I would argue she's getting worse. And that you see that in the balance of the rest of the case. And it's notable that we essentially say, hey, she's not going, she stopped. And I think she had. So when you look at her last appointment in this string is March 4th. We then filed April 4th. It had been an entire month with no appointments that she had, no mental health appointments, which doesn't make a lot of sense if you're continuing treatment. After we filed, she then runs out and gets an appointment and says, oh, I'm still going. Look, I'm still going. But it's only days after she receives our declaration. So she's trying to repair that, but that only comes as a result of the litigation, not as a result of her genuine desire to work on her mental health issues and acknowledge that she has them. Again, so we see more than a month of gap in her treatment records. That is a concern. And when we see no progress, that is a concern. And when we see dysfunction, that is a concern. And these concerns, laid on top of the other evidence, presents a substantial risk to this child. When I talk about dysfunction, we see 20 911 calls. We dispute the dates. They don't dispute the calls happen. They don't dispute that it's call after call after call for things that are not emergencies, frankly. Things that are, and the claim is they're baiting me into violating. It doesn't even make sense. My client doesn't call 911. They're never trying to get her in trouble for violating. They're never in this position where they're claiming that, some kind of exchange, every time that she's kind of making these claims in 911, they're not panned out anywhere in this case file. Again, that leans toward the dysfunction and the deterioration, that this is somebody who is not getting better, not making progress. Similarly, her declaration goes on to talk about, this harassment and these lies, but doesn't give any examples of how my client is harassing her, other than just going to court and saying, hey, here's what's happening and here's what's not happening. And when he talks about, oh, he lied, I'm like, well, my client has documentation from the physician's office about their policies. He has a formal letter that Kaiser issued saying, hey, this is what we told you. And she can't see that for what it is. It's lies. Folks like that, again, we talk about that being dysfunction. It's important to note that that dysfunction in and of itself leads to behavior. And really the behavior is the problem. And it's the behavior that led to the protection orders that are in this case. The allegations of those protection orders have been consistent. They haven't varied for more than a year. The stories have never really changed regarding those. And I would argue that her behaviors have not changed either. And notably, when you look at that mental health treatment progress, it is also unchanged. She has not made progress. Her behavior has not changed. And that's noted in her own mental health records. As a result of that, the protection orders had to be expanded and also extended. Again, because she's not making progress. She's not in a position where she's acknowledging her own issues. This is, I'll check the box and go to mental health, but I'm not actually acknowledging I have issues. There's really zero insight into her own behavior and zero acknowledgement. The domestic violence here is critical. When you look at the guardian ad litem report, she talks about the domestic violence for only a few lines, and that is troubling. And here's why. This is very much at issue in this case. This was a 5-year relationship with this person. And sometimes when you get a little bit deeper into a case and some of the declarations have gotten buried by other declarations, what Mrs. is trying to do is act like all the declarations in the file just haven't happened and we're just going to ignore them and just say, oh, well, it just never happened. So I'm just going to sweep it under the rug. But there is significant evidence of domestic violence. We have 911 calls about the boyfriend. We have her own text messages. We have the text messages between her and boyfriend. And that's part of the court file. The text messages between Lacey and her boyfriend, and I'll read it. It says, "You've gotten in my face multiple times before. You scare the F out of me and I don't trust you. I've told you that multiple times." That's not a text message of a relationship that doesn't involve domestic violence. These are people who are getting into each other's faces, yelling, screaming. Similarly, there seems to be just a flat denial, or I'm just going to put on blinders and ignore the declaration of Caitlin Slagle. This was filed December 5th, 2023. And I'll read a paragraph because I think it's really critical. This is the boyfriend's sister. She says, "I've known all these parties for years and years. I has relationships with all of them, and states how she's worried that even writing this is going to hurt some of those relationships." So she sort of acknowledges telling the truth sometimes is realistically injures some of your relationships with folks. But she says Lacey and Michael's relationship is nothing but chaos. Seeing the fights break out between them, the obsession, the insecurities, and the threats was and is eye-opening. I have personally witnessed this. Within the last year, I have heard Michael tell Lacey to go kill herself while he was in a drunken rage. Then he drove off and was out of communication for days. Lacey is stuck with him despite all the threats made to her, about her, and even Brody. Michael has threatened to leave her and take all her things. He has threatened to leave her and Brody homeless. He threatens to kill her dog, Rudy. This is not safe behavior. These are threats which are indicative of domestic violence and should be taken seriously, not just shrugged off by Lacey. And it goes on. And it talks about additional incidents that have happened between these two people. And so when you have all of this evidence of this long-term domestic violence relationship, it creates a significant concern. And you put that together with photos of marks and burns that happened during the mother's time on the child. They're without valid explanation. Mother says, "Oh, it was a jump rope." I'm like, that doesn't make any sense. And we often talk about, does that injury make sense? Is that a child, is it their shins? Or how does a jump rope cause a burn to your neck and bruising to your back? That doesn't make sense. She admits to paddling the child in a text message. She submits photos of injuries that my client's like, those are actually my photos that I submitted earlier in the case, and she's just recycling them now and claiming that they're hers. And then similarly, she submits photos where my client's like, you can look at the date and timestamp. Those are occurring during her time. It's not occurring right after the exchange. She's like, this is the end of her time. This is not the beginning of her time where she's kind of getting the kid saying, hey, what happened? It's, hey, this is right before we're going to switch back. And she's sending these texts. She's sending those photos or what happened then. It's important to remember that domestic violence is a cycle, and without treatment, that cycle repeats. We all know that. And in this case, Mrs. is in full denial. Her declaration, the last one submitted, says there was no domestic violence whatsoever. She denies it entirely, despite lots of evidence to the contrary. And again, essentially, we have this statement of, well, he's gone, so just ignore it, just wipe it away. But domestic violence puts children at significant and exponential risk. I think it's notable. Domestic violence is a 191 factor that we have to consider. what other 191 factor would we treat this way? If someone was using methamphetamine and they said, trust me, I stopped using and I won't use it again, would that be the end of the story? Or would we say, you need evaluation, you need treatment, you need help? If someone said, I'm schizophrenic, but hey, I'm promised that I'm cured, would the court say, no need for medication, no need for treatment? If my client was the one accused of being the domestic violence abuser, the court would, or absolutely, there would be an evaluation, there would be treatment, there would be limited time. But why here, where mother simply says, well, he's gone, don't worry about it, ignore that it happened, move on. Act like this is just something to kind of wipe under, sweep under the rug. And that's where, there's no follow-up, there's no concern. And that's where we do have to talk about inherent bias, where it's important to note that we have one party is male and one is female, and we have traditional gender roles. And so that absolutely can play a part in, well, if Mr. was accused of domestic violence, there would be all of these things that we would be very significant about. But if Mrs. is the one that is exposing child to domestic violence, well, she says it's done. So we're just going to ignore that. Again, 5 years is a long time to live in a domestic violence abusive relationship. It's a long time for that child. It's a lot of it. That is a lot of abuse that child's witnessed. And to have that child be on that cycle and just ignore it is not appropriate. That is something we absolutely have to consider. It's notable when we think about the father's household, there are no concerns, really none whatsoever. And per the teacher, child's doing amazing. Child's doing great with father's consistency. Child's slowly returning to a healthy weight and a healthy BMI. My clients noted that progress. My client is making sure he's meeting all of the appropriate appointments, all the appropriate milestones. There's literally like no concerns when it comes to his household. When we look at Mrs., again, we have the verified dysfunction and risk of deterioration. We have protection orders. We have many calls to 911. We have the protection orders. We have the domestic violence with her denials. We have the photos indicating physical issues with the child as far as unexplained injuries, her admitting to paddling the child, locking the child in his room. There are very significant concerns that need to be fully investigated. We're here on just an interim report. We need a full investigation, and for that investigation to consider all the evidence, not simply child self-report, not each party's self-report, but to meet with each of the witnesses and to meet with all of the collateral witnesses in this matter. So what should the court do? In this case, my proposal is the court maintain the current parenting plan. The court should send us and get us, the court should send us to the Wednesday docket for a trial date. Trial dates are always a little ways out. We should get one on the books now. Likely, this is a case that needs to go to trial. There's obviously a lot of information on both sides that needs to be presented. The parties do agree that the child needs counseling, and my client is absolutely in agreement with that. The parties should select an agreed counselor if they cannot, that's not associated with either party or either party's, I should say, medical office or counselor. I always think that that's appropriate. And if the parties cannot agree, then the court can select. And we should do that within the next 2 weeks. I think there shouldn't be a delay or any further delay on that. I think that's a reasonable outcome for where we are. And again, some very significant concerns that deserve to be fully investigated in this case.
Thank you. Ms. Winkles?
Yes, Your Honor. There's an overall theme in this case, and that's one of a problem with credibility. Now, my client, when she went to the DVPO hearings and those hearings, she didn't really present a lot of evidence. What she was hoping is to maintain the relationship and essentially wait it out. But we really need to look at that because I think credibility here is the most important thing. If you'll notice from the text messages that my client submits, her and Brooke Adams, and I'm going to call Brooke Adams the stepmother, but the parties aren't married. They're not married. Brooke Adams stated a number of things, and so did Dad, that my client essentially went out of her way to stalk them and do all of these things. And they submitted some dates. My client, what she submitted is showing that these parties were very good friends. And my client, dad says, she told me that the new child that they had should have been hers and mine together. But what you'll notice is that my client was informed immediately after the child was born, and my client sent mom flowers. Dad says those flowers were to me. So mom submits the receipt to the court showing that mom ordered the flowers to be sent directly to the hospital room of Brooke Adams, to Brooke Adams, congratulating her on having this beautiful baby. That time that she had the child in the DVPO, and in this case, dad says that at that time she was stalking and she was coming to the house unwarranted and unwanted. That was a week after my client sent these flowers. Then we look at the next thing. They say that again, she's stalking them and she doesn't want them, they don't want her around. Well, that goes contrary to the fact that dad and Brooke Adams, their child, they let my client take their child alone. So obviously we have no concerns in 2023 of my client essentially doing anything to the child or doing anything to anybody, because they send their own child, or sorry, 2022, they send their own child to the parade with my client. And you'll see the text messages there. They say, where do we pick them up? Where should we drop them off? My client is alone with a child that's not hers. That shows this really intimate family relationship. You then see text from Brooke Adams herself saying, I'm so glad that we're friends. I'm so glad that we can do this and co-parent. They then invite her kayaking. They invite her camping. They invite her to the house. What happens though is you'll see that my client got upset. She got upset because Brooke made a statement about being able to get this child to do something that my client couldn't. My client overreacted and ghosted Brooke. That is when this all started. That was November 8th of 2022. Now, you'll see from all their pleadings that they go back in time well before that, claiming that as of October 2021, that my client was stalking them and harassing them and doing all these terrible things. That's really not the case. They claim that my client essentially threatened to kill them in May of 2022, but yet they invite her to go kayaking in June of 2022. She says, congrats, mama. At that time, according to their declaration, my client is stalking them at their house. We then see that they're claiming that they both were sleeping with firearms, but you'll then see the next text message saying, we would love to have you, can you go camping? And them saying no. Now, my client was with Michael Slagle this time. You'll notice the August 2023 text that was submitted from dad to my client, essentially saying that there were no issues. That they didn't think so. In November of 2022, did Michael Slagle and my client have a bust up? Did he get in her face and yell? Maybe. That occasionally happens in relationships. It doesn't say if the child was there or not. All it says is, you got in my face, you scared me, stop. That doesn't show any domestic violence. Now, what they've tried to do is strike any of these pleadings, any of this hearsay, based on a lack of foundation for my client's allegations of bedwetting and so forth. But what they attempt to do here is claim domestic violence when they're not in the house. They claim that there was a 911 call, and there was one 911 call concerning Michael Slagle, one, in a 5-year relationship, that said he broke a Christmas ornament. And he did. And she broke up with him. She left him and he was gone. That shows a clear indication that my client is not willing to put up with anything. She mentioned back in November of 2022, you got in my face, I didn't like it. Considering when he broke an ornament, she broke up with him and kicked him out of the house and kicked him off the lease. You'll see that from the landlord, not a party to this case. You'll see the lease, he's out. But what you see is that obviously she spoke to him and he stopped. Because we know he stopped because the next time he broke an ornament, she was done. He's moved out, he's gone. Yet they make this claim that he's still there. And who do they use to kind of reaffirm this? They use Mr. Slagle's sister. And my client claims neither Mr. Slagle nor my client have had anything to do with the sister for over 6 years. My client herself has never seen him in the last 2 years. This is the same sister that wrote a declaration claiming that she saw them somewhere, yet my client was at work and submits her work records showing that she couldn't have been there. There is a massive credibility issue here. First, we have dad making all these claims. Now, my client submitted no proof in the DVPO, so a DVPO was granted, or an anti-harassment order was granted. But what she's done in this case is actually submit the proof. And you can clearly see that on every day they state my client is stalking them. A couple of days later, they ask her to come over. They ask her to hang out. They say how great of friends they are. There's pictures of her with their children alone. This is clearly the case of a stepmother who got mad at my client's reaction and decided to get rid of my client. Now, why did my client call? Not 911. You can see that from the CAD reports. Why did my client call the police? She called the police because of this credibility issue. They had already made all these claims that were clearly not true. My client was incredibly frightened that she was going to get arrested or have something used against her when it wasn't the case. We can see this in some of those CAD reports saying, hey, I'm afraid that I'm going here and I'm afraid something's going to happen. What do I do? And that's all the CAD reports are, is I'm going here. I want to let you know. And the cops say, that's good. Keep telling us. So she does that. Now, Brooke calls 911 twice. First, she claimed that my client took, or essentially was at a game harassing her. My client wasn't even there. We submit her work records. Then Brooke called 911 when my client wanted to take the child to a monster truck show. We see these things. We see this baiting. We see this attempt to get rid of mother. We can also see this coercive power of Mr. We gave him, or they gave him, the medical decision making, and you can see his texts that state, well, I will decide. I will decide. And then they attempt to rely on this statement from Kaiser. Well, here's the deal. He told this court in ex parte, which again is not really what ex parte is for at all. It's for an emergency. Told this court in ex parte that only one parent was allowed. That wasn't true. Absolutely not true. Miss Turnbull does an investigation, finds out that's not true. Another credibility issue of dad. So what does he do? He reports to Kaiser, but he gives no name. They tell the person's name of who spoke to my client, yet he's self-reporting. Of course, Kaiser is just going to believe this. Yet another credibility issue. So what do they attempt to do? They attempt to rely on the teacher. This is the very same teacher that wrote a statement for the DVPO claiming my client had no reason to be at the school at the time. Yet my client submits that email to this court in this hearing. She didn't do it in the last one, showing that the teacher specifically asked my client to attend. And this is the same teacher that Mr. now wants us to rely on. The same teacher that's mentor, the direct supervisor above her, is the aunt of Brooke Adams. And they're going to say, well, the names are the same. No, that is the aunt of Brooke Adams. The fact is that everything in this is blown up, a credibility issue. We look at the supposed injuries of the child. The child goes to daycare, rubs a rope on his neck like this, goes to my client's or goes to dad's house. Dad takes a picture of it and you'll see the text. Dad said, what is this? Mom says, rubbing a rope on his neck at daycare. Dad then sends a text later saying, oh, we're so sorry. It's all right. It must have been the hot water of the shower that made it appear so much worse. It wasn't bruising. It was clearly an irritation. Hot water exacerbates. Hot water vasodilates, causes blood to rush to certain areas. As soon as the kid dried off, as soon as the temperature went down, kid was fine. I want to remind the court that this is the same dad's house where the kid has had black eyes, bruising all over his body, got into an accident and had to be air flighted because he wasn't wearing a helmet and dad wasn't watching him. These are the issues that are at dad's house. Dad is the one who has always used corporal punishment. Mom paddled, a little smack on the rear end one time. There have been no allegations prior to today about any domestic violence occurring at mom's house. What you're seeing is an attempt, a frantic attempt, to throw spaghetti at the wall because all of dad's things have been fabrications. And we know this because we have text messages on every single one that backs it up. Dad says A happened. We then look at the text message. Dad lied. We have B happen. Look at the text message. Dad lied. And this is the thing, is my client never used these texts. Most likely they didn't believe they existed. And so when my client now brings them up, oh no, we have a problem. Dad's been lying for the last 2 years. What do we do? Let's say that she's in a 5-year domestic violence relationship. Where's the evidence of that? We have a sister who knows absolutely nothing to Mr. Slagle. And we have Mr. Slagle saying some really horrible things after they broke up, which is why my client broke up with him. You can clearly see that from the lease. Now, we talk about whether or not my client has had mental health issues. So essentially, we're asking the court to wonder why a woman who's been an amazing mother to this child and has had 50-50 custody of this child throughout his life, his grades were absolutely perfect until essentially November 8th of 2022, which is when dad's campaign against mom began. So we're wondering why there is an issue with dad or issue with child's grades. Well, child's grades are absolutely fine until November of 2022. Then we see a problem at school, and now apparently his grades are fine again. Let's think what happened there. That's when dad's campaign against mom started. Dad's disparagement against mom started. The child's of course doing all right now because there's no reason to disparage mom because dad won. Dad doesn't have to, mom has almost no visitation. There's no reason for this campaign at the moment. So child is of course doing well. What child would do well is if dad stopped lying to the court, stopped fabricating, and stopped attempting to get mother in trouble for things that are easily proved and that mom's not doing. The fact is mom had an evaluation. And what they're claiming is we see no change in a month. A month, if mental health professionals were able to help somebody in 1 month, this world would be a much different place. But how can mom get better when the fabrications are continuing? Mom has had over 50-50 custody for this child's entire life. That's pulled away for things mom knows are false. Mom knows dad is lying. Mom knows dad has made statements that are clearly not truth, and she has proof of it. What mother wouldn't have a mental health problem from that? She's essentially had her visitation cut by more than 75% for something that isn't true. Dad has made it very clear he does not want mom in this child's life. And the GAL is here today, and I think the GAL would concur with that. Dad wants nothing to do with mom being in this child's life. Mom is the opposite. Mom wants dad to be involved and has tried to facilitate that the entire time. So again, we're asking to rely on the teacher's declaration, a teacher that, contrary to district policy, wrote a declaration 2 cases. The fact is teacher did that because this is a very tight community in Castle Rock. It's very small. Her mentor is already the aunt of Brooke. The only reason she would put her teaching up for that is obviously for a good friend or a family member. We've seen dad have no problems with mom. We've seen them get along really great. There's no stalking. There's no mental health. Now, dad, what does he do when he finds out, when he knows that everybody knows he's lying? He starts bashing the people. And we have to really think about who he's bashing here. Ignoring mom from this situation, who is he bashing here? Who is dad lashing out at? The guardian ad litem is number 1. First, he takes a Scrivener's error of an accidental date put in, and he says, she didn't do a report. This is Amy Turnbull we're talking about. This isn't some GAL that this court doesn't know. This is a GAL that's in a significant amount of cases that has clearly stated no issues in mom or dad's house. Then we look at the evaluator. Then they say, this is a social worker. She's not able to do this evaluation of my client. Well, actually, the law says she can. And she has more education than a simple therapist. She's a licensed clinical social worker who is able to do evaluations. The WAC actually says that in it. So then dad says, I didn't have any collateral time whatsoever. And what do we have from the therapist or from the evaluator? The dates and times of speaking to dad, what dad said. So obviously, once again, another lie of dad. And one wonders if dad has a mental health problem because he continually lies to this court over and over again about, she said she wanted the baby to be mine. The flowers were sent to me. She stalked us at her house. We see a picture of her waiting here. Yet the text messages are between them saying, hey, come on over. Do you want to do this? Do you want to make cookies? Do you want to do this? All of this stuff is lies, and yet dad keeps doing it. Then he says she can't come to the court. She can't come to the hospital. Well, she clearly can. I never spoke to that woman. He clearly did. Every single thing that is being said by dad, which is really shocking because they're very easily disproved, as you'll see from my client's evidence that is very pointed, is a lie. Then they say Michael Slagle's still there. Michael Slagle's moved out. There's a lease that shows that. There's an empty room in the picture that shows that. They really are grasping at straws. Your Honor stated in our last hearing that if there were no concerns on that GAL report, that you would be looking back at the 50-50 plan that these parties have had in place for over 6 years. The GAL has no concerns. Now, the school is a problem. My client understands the child is in school for another month and a half. What my client's proposing is that we slowly expand the time until the child's out of school. And then starting in summer, we go back to the 50-50 plan it was. The fact is that there have been enough fabrications. My client's literally lost visitation over lies that text messages show that that's what they are. He continually lies to this court. There's no neglect. There's no harm in my client's house. And when they show you these bruises on the kid, I ask Your Honor to look at the date, because these were taken on day one of mom's visitation, which means they happened at dad's house, because you can clearly see the bruises losing color over time. We have a series of photos. Every injury that happened, and we're not saying dad's abusing this kid. This is a little boy who could fall off a bike, who could, jump off a ledge. Little boys do all kinds of things and get injured everywhere. They get injured at daycare. They get injured at, they're little stuntmen in a way. But what we are saying is dad's abusive use of conflict, his attempt to remove mom from the life of this child, is appalling, especially when this started over mom overreacting to Miss Adams, and it could have been ended there. But instead, dad and stepmom decided no more for Miss Klopp. She's out of the picture. We're going to get her out of the picture, and started a campaign essentially against her, and have been successful until now. We probably could have ended this had she submitted all this stuff back when she first had it, but she didn't. She has submitted it to Your Honor now. We ask you to review the evidence in full, because this is a travesty. It's essentially a travesty of justice, considering these are all things that can be proven. We'd ask Your Honor to go to this expanded to 50-50 time. And I'd also ask Your Honor to not allow any rebuttal, because this is not Mr. Klopp's motion. This is a GAL review only. Miss Baldwin's already spoken. I've now spoken. I'd ask for you to speak to the GAL, but this is not nobody here is the moving party, and it would not make sense nor fairness to allow either of us a rebuttal. So I'd ask that you speak to the GAL. Thank you.
Do you want to hear from Ms. Turnbull?
Thank you. I have spoken with the counselor. I've reviewed the mental health report of Ms. Klopp. I've spoken with the regional director of Kaiser, who manages the sleep study. This was all in my report, and at no point did anybody have concerns with Ms. Klopp. The parties are aware there was a recent CPS report by one of the school counselor, and I spoke with a CPS social worker who was in Ms. Klopp's home last week. She also did not have any concerns regarding Ms. Klopp or her home. I have not, all of the third parties that I have had contact with have not had any concerns. I did have concerns that Mr. Klopp did manipulate some of the information. The sleep study, sent me an email afterward that said he did have conflicting information. But when I spoke with the regional director, she did report to me that she contacted both Mr. Klopp and Ms. Klopp and informed them that essentially two adults could be in the sleep study, that they would have possibly a second room that they could use. They could have one person on the floor, they could take turns, that they would accommodate this, that two parents could be there, that essentially the one adult had to be present. You could not just leave your child. That doesn't mean that two people couldn't be there. And I asked her if in the records it indicated anybody had contact with either parent after her conversation, and she said that they had not. There was no record of any contact with the parents regarding this issue after she had called them. So that gives me cause for concern that that information, even if it had been conflicting before, her call was to clarify. And so that's where that piece of information is. I do have some concerns about Ms. Klopp's previous relationship, and I do think that some education and counseling regarding domestic violence is appropriate. I do think she was the victim in that relationship, not the perpetrator. And so having a domestic violence evaluation would not be helpful necessarily in that sense because she was the victim. I think that it would be a counseling recommendation. So I think that's where we need to go on that front. Let's see, I'm trying to think of any other questions that you may have. In terms of recommendations for moving forward with the parenting plan right now, I do think Brody is really significantly in the middle of his parents' conflict. And that is my biggest concern right now. When I spoke with him, he essentially said he tells his mom what mom wants to hear. He tells his dad what he wants to hear, and he doesn't really know what he wants. But I think that by giving those answers to each parent, that is just stoking the fire of the conflict between both parents, and they really need to stop asking him what he wants and asking about what's happening in the other home. And he needs to be in counseling. And I have expressed this to both attorneys that it's critical, and the CPS agent also is going to be recommending that. So he's sad. He's just a sad kid right now, and he misses his mom. So whether you decide to go back to the 50-50 or you want to keep more stability throughout the school year, I do think some more time with mom would be appropriate.
So one of my questions has to do with long-term plan for a final report. What are you looking at? What are you thinking you'll need?
I would say another 4 to 6 weeks.
Okay. All right. Thank you. So in regard to the idea of rebuttal, when new information is brought up, it's not a matter of whose motion, it's more a matter of one gets to hear all the argument of one and then be able to respond and add additional, but that doesn't give the other the ability to respond to the information that's brought up by the others. So with that, Ms. Baldwin, if you can address just any new information.
So a couple things. Again, it's concerning that we have records from the sleep study that say one parent to attend. We have a letter from Kaiser themselves that says, yeah, we told you it was one parent directly. This is their official in writing statement that says, yep, we told dad it was one parent. We probably told mom something else. That's on us. But it's couched in my client being malicious when he wasn't. And it's notable that this is a sleep study. Mother's request was, despite the difficulties between these two people, she wanted to come and sleep on the floor next to my client during the sleep study, which it would absolutely have disrupted the efficacy of that sleep study. Her interest was herself. She was most important in that situation. Not, hey, this is not a surgery. This is just a sleep study. Child is most important. This is just getting information like a blood test. They don't both need to be there for a blood draw. So again, even Kaiser says, this is on us. We told you different information. And all the documentation supports that my client in no way did this maliciously. And it's frankly logical that both parents were not there. As far as the domestic violence, the claim that domestic violence has not been on the plate from day one is contradicted by the records. And again, I quoted records from back in December. So That's absolutely been on the table since day one, and very clear. We have never said that Mrs. was the perpetrator, but that instead she is stuck in a cycle of violence, and that absent treatment and acknowledgement that she needs treatment. She's in a pure denial state right now. That absent that acknowledgement, that the cycle will repeat, and that cycle puts the child in danger. Similarly, the statement that my client lied and said he's never had collateral input. No, his statement to the court specifically was, I was not allowed to give collateral input on the domestic violence issue. That was the issue he was not allowed to provide any input on. So he says, like, they would take information from me, but on this, they just said, nope, you're not allowed on that issue. So that's specifically what his declaration states. So not that he doesn't have any input, but very specifically. And again, that's one of the main issues in her mental health. The fact that she's receiving mental health treatment is good. That has not been on board just recently. She's had mental health treatment since January, and there still is in a position of no progress. As far as the claim that the protection order was not defended against, that's also not accurate. Miss Klopp in this case filed her own protection order, which was denied. So she filed sort of a collateral defensive protection order, and that is how she responded. So to say she didn't respond into that file, she just created a different file that was heard at the same time. So again, that's sort of a bit or is directly misleading. So in this case, what is in the best interest of this child? Stability is in the best interest of this child. The child getting into counseling, the investigation being fully fleshed out. And it is concerning that we have reports to CPS that are coming from not either party. These are coming from third parties who are then saying, hey, child's making some concerning statements, and investigations are occurring as a result of that. So again, that leads to their concerns, but those concerns are underpinned with evidence. And so we have to do what's right for the child. Child is priority. And so again, I think that my suggestion is a good one, that we maintain the current plan and set us to the trial setting calendar to get a trial date. I think that this case is likely one that will proceed to trial.
Brief response, Your Honor. Very brief. The CPS, we have no indication that CPS was called on mom. And in fact, I believe one of the CPS calls was against dad's house. Second, the DVPO that my client issued was actually dropped. It wasn't denied. Finally, this child has stated to the GAL that he's sad, that he misses mom. There is no reason why it would not be in the child's best interest to increase visitation with mom. What dad is asking you to do is, let's let this child continue to be depressed until we set for trial. There's no reason. There have been no concerns by mom, by anybody. Should mom go to counseling for being a victim of DVP, domestic violence, if she is? Absolutely. My client has no problem doing that. But there's no man in my client's house. There's no boyfriend. There's no immediate threat to the child because there's nobody in my client's life. There's just my client and the child. So my client would ask that we do what the child wants and needs. We help the child. We expand mom's visitation, and come the date school gets out, we go back to a 50-50 plan. Then we wait for the trial, which most likely will be at the very end of the year, given the trial schedule. And hopefully that summer with mom and summer with dad, if these parties can just stop talking to the child about anything, and we can put that in the order. Neither party speaks to the child in any negative way about the other parent. Either party asks the child about anything. Neither party does this. And the child's in counseling at that point in time. So the child can say if somebody is violating this easily and has this third party to talk to. But there's no reason why this child shouldn't see mom more. There have been, the only person that has a concern with mom is the person who is fabricated with evidence that clearly proves that, not just the Kaiser, but a whole host of things, including dates and times. So we'd ask for expanded visitation until June 14th. And then come June 14th, we go back to a 50-50 plan where there's clear measures in place that allow neither party to talk to the child about the other house. Let's just pretend the other parent doesn't exist for the child. Enroll child in counseling immediately. And the GAL can then review and drop in as needed to both parties' home. That makes sense. What doesn't make sense is to punish mom for a relationship that no longer exists and to punish child. That's really what we're doing by leaving child away from mom. This is a depressed kid. That's not fair to him. And when school's out, we have no educational issues at that point. School's out. So we'd ask for the expanded visitation as far as your honor sees for the next month and a half, and then go to this, I guess not even a month and a half now, and then go to a 50-50 plan, and then set the GAL report, let's say in July, come back and we can go from there. Set a trial in the meantime, but let's be honest, the trial's not going to be until November or December. Thank you.
So first question I have is, when is school out?
Usually June 10th
14th.
to 15th.
I think it's the 14th this year.
Okay. All right. So first, I'm going to talk to the parents. One of the things that makes me very angry and upset is when parents decide that they are going to involve their child or children in the middle of a custody matter. Those children or child, in this case, has a right to love both parents and not be torn apart because the parents are going at each other. I expect you to act as adults, let the child be a child, and do not involve this child in the middle of this legal action. You're not to talk about it. You are not to talk about what goes on at the other person's house. You are not to talk about and ask that child anything about anything related to this case. That child wants to love each of you. So stop putting the child in the middle. It scars them. It scars them for the rest of their lives. So stop. In regard to what's going to happen from here, the court has reviewed the interim report as well as the pleadings associated with it. The court understands it was an interim report, but what the court also sees is a lot of pointing fingers and blaming everybody else but taking responsibility, and that's for both parents. That always makes it difficult, so credibility becomes a big part of this. And obviously, when all I see is a picture of somebody sitting on Zoom, that can be very difficult. And that's where the court does rely on the guardian ad litem to make that investigation and give at least some sense of where that is. And the court has some issues with credibility on both sides. Again, it seems to be a who's going to win rather than what's best for our child. So the court is concerned with the many issues that have been raised on both sides. And the interim report simply is not going to get to the bottom of those issues because there are a number of them. So based on the files and record and figuring out what's in the best interest of this child at this time. And this is not a decision to be taken in the sense of a final decision, and this is a temporary order. This is a process that needs to occur. And so at this time, in regard to what the court is going to do is going to change the current schedule just slightly, because what the court does not want to do is upset this child any more than the court needs to. So what the court is going to do at this time, and I apologize, I think I was looking at the parenting plan when I did this, came up with this, but the mother is going to be having the child the first, third, and fifth Thursday from the time school is released, or 9 a.m. if no school, to Sunday at 5 p.m. That is commencing this Thursday. And then the mother is also going to have the child, I believe she's having the child on Wednesdays, Ms. Winkles, is that correct?
Yes, that's correct, Your Honor.
Oh, no, that's not
Oh,
correct.
I'm sorry. Oh, what's
There's
correct?
no
I have a-
midweek in this.
Oh, there, yeah, my apologies.
Okay, so there is no midweek. Okay.
Correct.
So the mother is going to have a midweek, and just basically the same time from the time school is released until 8 p.m. And if no school, then at 9 a.m. That would be on Wednesdays. I thought about making it Thursday, so Thursday was consistent, but that creates other problems, I think, down the road. So I made it Wednesday. I don't know, council, Wednesday or Thursday, I'm good either way.
I think Wednesday's fine, but I would make the suggestion, because it avoids contact between the parties, instead of Thursday to Sunday, if you do Friday to Monday, mom picks up from school, she drops off at school, the parties don't have any contact.
Yeah, does that work for you, Ms. Winkles?
It does, and what I can also suggest Tuesday instead of the Wednesday. So the way the schools work is they all have a shorter day on Wednesday. That way the Tuesday, I guess Wednesday after school is fine. I was just thinking about, I think I got it wrong. My apologies. I was looking at a different schedule. I think the Wednesday is fine. I think they have a shorter day on Wednesday, and then turning at the 8 p.m. is fine. My apologies.
So it'll be Wednesday for the midweek, and then that's fine, Friday to Monday. That's fine, but if they don't have school on Monday, then it would go until 5 p.m. that day.
Okay.
So that changes that time just a bit. And if no school on that Friday, 9 a.m. If no school on Friday.
Very good.
All right, and then the mother shall not have the child around Mitchell Slagle. I think that's the name. And then the court adopts number 2 through 5 of the recommendations of the guardian ad litem. And in regard to the counseling, I think it was Ms. Winkles, I can't remember who it was that suggested that if the parties can't agree that it comes back to court, I'm not sure what, it doesn't really matter, but see the parties agree. I don't know, because Kaiser is the provider, if that somehow plays into who's available for that. Do you know, Ms. Winkles?
It does. Kaiser has their own in-house child counselor, Dr. Leah. I don't know if that's the child's doctor, but that's pretty much every child's doctor in this area. She would make a referral based on the recommendation, and we can actually send that directly to Kaiser, and they will refer the child to a child psychologist.
Okay. So essentially I'll rely on that. That's who the child will go to. So it's covered by Kaiser. And then I understand that there's some counseling, the mental health counseling happening that needs to continue to happen. But what the court also wants is for mom to go to the domestic violence class at the shelter. And file proof that that was done. Ms. Turnbull, were there any other evaluations or anything that you wanted?
Not at this time, no.
All right, so in regard to the summer time, the court is not ordering. I do want just a standard holiday schedule that needs to occur.
And that's already part of the plan.
Okay. Let's see. So I have counseling that. And then what I'm going to do is set this on for June 2nd, excuse me, June 4th. For a final guardian ad litem report. I'm hoping Ms. Turnbull can have it done prior to that time.
Yes.
And then look at the summertime and what the schedule is going to be like from there.
The court, so council reference maybe setting out into July because we won't have the child's counselor's input likely within the next like 3 weeks. I didn't think that was a bad recommendation, is to allow for the child's counselor to have input.
And Your Honor, I'd ask for it to be in June before school gets out, because then we're using half of the school, we're using half of the summer where a child can be integrating back into mom's house, if that's going to be what the court decides. Otherwise, we're looking at less than a month to integrate the child, which will be difficult.
It'll be June 4th. That's when the guidelines report is supposed to be done. Hopefully we'll have at least some information from that counselor by that time. If not, we can address it at that point, but I do want to have something going before summer.
And then the guardian ad litem's recommendations included you're adopting 2 through 5. That includes my client taking a parenting class. He's already done that. So I just asked that we strike that because my client's already completed that and filed proof of that with the court.
Okay, yeah, that can be stricken.
And
So
my client has taken a parenting class as well.
this investigator recommends Lacey Klopp does not introduce Brody to a new romantic interest for 9 months. Court's adopting that. We already talked number 3 about the counseling. Number 4, if that's been done, then that's fine. That can be stricken. And then 5, that the mother discuss signs of an abusive relationship and appropriate boundaries with her counselor. Which is essentially already talked about as well.
Presentation in 2 weeks.
So in regard to presentation, I'll go ahead and add it to that May 7th.
Okay. All right. Thank you, Your Honor.
Okay. All right.
Going to call number 2 on the docket, 19-3-00361-08, Klopp v. Klopp.
That matters. Ready?
And Your Honor, I don't know if you saw my order that I put in. I don't know where it went. We filed it on the 17th, but it disappeared. I have very minimal issues with Miss Baldwin's order. So it's up to you, Your Honor, if you want to have one that's just from that hearing, or if you want parenting plan to include it. I can argue either way. Both of them are minimal.
So in reviewing that, I would prefer to just work off of the parenting plan. That seems to make more sense. So I looked at both as far as that goes, but let me get that out here. Okay, I'm looking at the amended temporary parenting plan proposed by Ms. Baldwin. Tell me what your objections are.
Very minimal. And my apologies to Miss Baldwin. This is my dropping of the ball, has nothing to do with Miss Baldwin. She got these in quite early. Section 8B, it just says every first, third, and alternating fifth weekends. Your Honor stated every first, third, and fifth weekends. The word alternating needs to be struck, and that is on, and I did submit the transcripts for this. That would be on
Page 4.
Yes, Your Honor, page 4, and it's also in the transcripts on page 45 of the transcripts if you want to look.
Ms. Baldwin?
Alternating is most common, so whichever Your Honor intended.
I intended just fifth weekend. There are only 4, and I was just looking for some additional time. That's fine. All. So I'll go ahead and delete alternating. Okay.
And then the only other issue that we had was on page 9 under 14H, the telephone access. Beginning at the age of 10, I just wanted to make sure that this was still what your honor intended. We didn't speak about it. It seems like they are calling the child at different times. I just wanted to make sure that that was still intended, given the expanded visitation.
Ms. Baldwin?
Not argued, pled, or ordered. We shouldn't be changing things that we didn't argue, plead, or order at that hearing. So I would ask we just leave it alone. If the parties want to negotiate something separately, we can do that off docket.
Yeah.
And that's fine.
Okay, it will remain as currently set.
And that's actually my only issue. And again, my apologies to the court and to Ms. Baldwin for dropping the ball on this one.
All right. So with that, Ms. Winkles, are you okay to put approved via Zoom?
Absolutely, Your Honor.
And then I would just ask we also sign the order on hearing that just has the clerk's action in it for the review date.
And that's fine with me as well, Your Honor.
All right, I have signed off on those orders. Anything else?
No, Your Honor.
Your Honor. Thank you.
All right,
Thank you.
that concludes that matter. Before I go any further, are there any agreed continuances? Agreed continuances?
I believe
Yes.
I believe that's Ms. Winkles and I. So I believe we have one on CLOP and CLOP. That's number 3 and 4 on your docket, 19-300-36108. We were on to review the guardian ad litem report. The guardian ad litem wanted to have an opportunity to review some of the depositions that we were able to complete. We were only able to do those last week. Usually those take about a week or two to get the deposition transcripts in and then get them to the guardian ad litem with a rational amount of time for her to review those. So I was thinking probably a date in early July, and the guardian ad litem can pipe up and let me know if that makes sense to her.
And I have July 2nd, July 9th, July 16.
The 2nd is fine with me.
And I believe that's fine with my client as well.
Okay.
And my apologies for no camera. My internet keeps going out this morning.
Okay.
Oh, there's Ms. Purple.
Sorry, I'm just moving slow. Let's see, July 2nd would work for me.
To Stephen Baldwin.
And
Are we dumping him?
July
No,
9th or the 16th. Any of those is fine.
Let's go ahead and go to July 2nd.
Okay. Very good.
That works. Thank you, Your Honor.
Thank you. Any other agreed? Going to CLOP v. CLOP, number 3 on the docket, 19-3-00361-08. I have Ms. Baldwin, Ms. Turnbull. Do I have Lacey CLOP?
You have Mr. Roberts, who's new to the case.
And Your Honor, we sent an NOA in yesterday. It should be there any minute, but I'm appearing for Ms. Klopp and I'm up to speed enough to discuss this hearing today. So we can go forward.
So we're here for the review for the guardian ad litem report. There was a little bit of additional information that we were waiting for. But we're just able to get that in within the last bit, but it's quite a bit of volume. So we were synthesizing it to be able to provide to the guardian ad litem. So I know that she was sort of waiting on that, given that the report's clearly not in the file. I think this should stay with Your Honor. And so I would ask that we just set to the next docket that Your Honor is available. And I think that's
August 20th.
That would be fine. And my client's not available through August 6th. So we would, the 13th or the 20th, and if the 20th is the first available, then that's fine.
Oh. Mr.
I'm available the 20th. What I was hoping to do, and I believe I spoke with Ms. Turnbull, and I believe she has some update, but I'll defer to her. This has been an ongoing situation with delays due to additional information that Ms. Baldwin's tried to get to Ms. Klopp. My understanding is that Ms. Turnbull, her inclination thus far has been to expand my client's time. This was on June 4th. We are now at July 23rd, and we are about to be at the end of summer without my client having any expanded time. The very least, I'd ask for, I don't have an objection to the continuance because I know Ms. Turnbull needs to finish her report, but pursuant to Ms. Turnbull's input, I would ask that my client has expanded visitation between now and that hearing, because the delays are solely because of father doing this last minute fishing expedition, for lack of a better term. It may determine the outcome, but I doubt it. And at the very least, if Ms. Turnbull is on board with expanding some time, giving my client more than she currently has between now and the next hearing, that'd be great. I also understand that some of the outstanding information that Ms. Baldwin is trying to get to Ms. Turnbull is pursuant to at least one subpoena that was objected to, that was never calendared for the court to determine whether the subpoena should go forward or not. So I know that's not on the docket today, but I did want to raise that because it sounds like there's probably an issue there, but I can't speak more to it at this point.
So in regard to this idea of expanding or changing one, I have no report and I get it. Ms. Turnbull is still working on it too. I have no written motion. I understand, Mr. Roberts, you just joined. And at this point, I don't have any information that I've reviewed. And so where things are even at, I don't have a clue. And I don't want to make a decision based on a recommendation. It's a recommendation, no offense to Ms. Turnbull, but I have no information in front of me. So that's my concern at this point.
So we'd ask that we set to the 20th. I'm happy to talk with Mr. Roberts off docket about discovery issues.
And if we are going to have it set over to the 20th, could we at least get clarity on when all of this documentation is going to get to Ms. Turnbull, so we're not here on the 20th kicking it out till September 15th? And again,
I think that Ms. Turnbull should be able to provide her report by the 20th. Either I have the information and I can provide it, or I don't. So at some point, I think it's reasonable that she prepares a report.
So Ms. Turnbull, where are you at with the timing on this?
I'm substantially completed with my report. I could finish it within a few hours. I'm just waiting on the information that Ms. Baldwin would like to provide.
We have some subpoenas that are supposed to come back this week. And so I'm anticipating, and which they weren't due until this week, just the timing that we had to give. So, and those I think would be important depending on what's received.
and I guess my concern, Your Honor, is this is a case that was, the jail report could have been finalized the last week of May, and then subsequent to it being right on the edge of the deadline, further subpoenas and depositions have been taken to just drag this out. So what I'm asking for is some kind of hard date to have this information to Ms. Turnbull. Otherwise, there's going to be potentially new subpoenas, new depositions to drag this into October, November.
There's no reason why it would extend past it. Ms. Turnbull is largely complete and waiting on the data. I should have until the week before the 20th to provide it, because that would just be supplemental, and then weigh however she wants to weigh it.
Your Honor, it sounds like
Regard to that.
And it sounds, sorry, Your Honor.
Okay, enough. So in regard to that, looking at August 20th, I want all information to Ms. Turnbull by August 9th. Then Ms. Turnbull can finish up her report and get it sent out.
Very good. Right. That's it for today.
I'll go ahead and set it over to the 20th.
Thank you, Your Honor.
Thank you, Your Honor.
I believe number 1 and 2, CLOP and CLOP on your docket will be an agreed continuance. This was on for a guardian ad litem review as well as a motion to compel. Guardian ad litem just provided her report yesterday, and essentially clients haven't even had a chance to review it yet. And so we're asking for a 2-week set over, give everybody a chance to review and respond. We were also on for a motion to compel. That response was also received late last week. So it makes sense to just set both matters over 2 weeks. I think that would take us to September 3rd.
Okay, anyone else here on the CLOP v. CLOP matter?
The guardian ad litem is here, Your Honor, Amy Turnbull.
Okay.
All right, so I did see the, what was emailed yesterday. My understanding is the guardian ad litem has been ill. And so understandably has not been able to get, the interim report done. So if I'm not hearing any objections, so we'll set the matter over 2 weeks. What date does it?
That's the 3rd.
Okay. We'll go ahead and set number 1 and 2 over to September 3. Number 3 and 4 on the docket, 19-3-00361-08. Clop v. Clop.
That's ready.
All right, there are 2 matters on. First is the final GAL report, and the second is a motion to compel. We have Ms. Baldwin, we have Ms. Turnbull, and we have Ms. Klopp here in the courtroom.
And the court had indicated already that you're setting over the final GAL review 1 week.
Correct.
Okay. So as to the motion to compel,
So let me clarify in regard to the GAL review. I did receive your motion to adopt, but again, the court doesn't find that it was timely for all the paperwork to get done and responses to be done. And so that's why I'm not considering it today and setting it over. Okay.
Thank you.
All right. So that's what's going on there. And then I have the motion to compel. Go ahead, Ms. Baldwin.
Thank you. So on the motion to compel, we're specifically looking at, and this is to compel, and again, a request for fees and sanctions in this case, regarding a couple specific pieces of information that are really crucial to being able to show a number of underlying factors in this case. One of those first items is the Google account. Although the account is provided, what the account shows is that it was substantially edited prior to being provided. It showed that information was edited, information was deleted. There was a repeated takeouts, which is the sort of Google term for redacting information and removing it from the file. And then the file was downloaded essentially 19 different times in order to confirm that all of those takeouts were successful. As we know, sometimes you'll have computer data that's in one place and then another. And so there was sort of an assurance that the other party wanted to make sure that all of the information that they didn't want shown was removed from the file. So, and you can see that as attached as Exhibit B to my client's declaration of July 23rd. She also changed the settings within her Google account to make this possible. So again, this is not a whoopsie. This is not a mistake. This is a very intentional, methodical person who is going through making those changes, changing those settings, and then removing the information that would be harmful to their case before forwarding that information on, making material changes. Similarly, we had requested communication, essentially her social media communications. There's a significant dispute about whether some relationships continued. And what you see is essentially Mrs. continues her, you see her stop her communication with boyfriend on one date, and then her social media app usage with Messenger and WhatsApp then explodes thereafter. And she doesn't provide that information at all. And in this case, she says, oh, well, that's all work related, and so I don't have to provide it. And my client says, absolutely not. We have nothing from not even a single employer that says this is in any way employer related. It would be very odd for an employer to use an app like WhatsApp for communications. And then when you look at the communications themselves, that doesn't make any sense. Her communications, you can see her using this, you can see her using it to message on March 6th is really when this starts. That doesn't align with when she started with that employer. So, so again, that doesn't make sense if she's saying this is work related. Similarly, you can see that the messages themselves, again, we can't see the messages. That's part of what she's not providing, but you can see her messaging at 11:30 at night, 1:15 in the morning. Those aren't work times. That's not when she's working. So again, that doesn't line up with, oh, this is work related, so I don't have to provide it. So again, we have somebody who's not providing these critical pieces of evidence, materially changing them. In the same vein, we have Snapchat, which is another social media app where she claims, oh, well, I deleted it, so I don't have access to it. But the app itself, and again, my client shows that she was active on the app as of April 11th, and this request was served, and that's 14 days after our request was served. So if she deleted it after our request was served. So again, withholding evidence, destroying evidence, or deleting it. So we're in this situation where we have a number of critical pieces of evidence where my guess is that they would show things that Mrs. does not want seen, that they would prove things that she doesn't want proved. And so in this case, she's just saying, well, I'm just not going to provide it or claim it comes from other people, or claim, essentially that these are communications with other people, but I won't show that. So in this case, that causes substantial issues. So what we're asking the court to do is first order her to provide it. We believe that it's most likely that she does have a copy of the original Google account, that she removed it, looked through it to find all the things she wanted to delete, and then deleted them. So there is a chance that she has that original file that should be provided. Similarly, she should be required to provide the Snapchat as well as the other social media apps like WhatsApp. Those all need to be provided in full. There's just no excuse for not providing those, especially when we have no verification that they are from her employer or in any way associated with her employer. And at this point, she's had more than a month to procure that. So again, just not really an excuse there. Finally, we should set a date to review compliance. If she has not complied and not provided those things, then at that point, it's not sufficient to simply issue a financial sanction, because then what that means is that parties can simply buy non-production. If something's going to harm you and all the court is going to do is fine you, great. For some parties, that would be an excellent choice. I would choose not to produce this if I know that the cost is $1,000 sanction. Many people would say worth it. That's a great, that they're willing to pay that cost. So simply a cost alone is not enough, especially in a case like this. So the court should set a review date, and if it's not provided and not provided in full, then the court should then make findings that are associated with the request. And those are findings to the findings in the negative or contrary findings that the court rules authorize the court to do. So depending on what she provides and the quantity of what she provides, I think then I would propose findings if she does not provide all of the data that we have requested.
Go ahead, Ms. Klopp.
Yeah, for the Google account on March 27th, I had said that Ms. Winkles had asked me to pull a Google takeout to see if I was tracking my location. And I put that information in a declaration on March 28th. I didn't even get the discovery request from Ms. Winkles until April 1st. So I wouldn't have known prior when I took that takeout. And when I did do that takeout on March 27th, all I had deleted was an old iPhone that said it was still attached to my account. I had numerous other things that I had to get for them, my Instagram, my Facebook, which they have all records of that I had downloaded. On April 11th, I sent my Google takeout information to Erin, and I even provided the email that said there was errors. When I was downloading it, I'd open the file and the file was blank. So I don't know what was going on, but that's why it was essentially downloaded so many times. I never deleted anything or intentionally tried to withhold any information on my Google. I don't have any of those files. I had a computer that my ex had given me last year. And when we had that crash for the software on July 19th, my Adobe wouldn't work on that old computer anymore. So I had to finally use the Lenovo laptop, and Brody had always, my son wanted computer. So I deleted everything off that computer and made it a kid's account for him on it. So he has that laptop, but there's nothing on that. For WhatsApp, I didn't provide anything for WhatsApp because the number 9 I can't even say it, says to provide in which it's related to any way to this action. And there was no way it was related at all. It's all work related. I use it for travel. Also, when I have clients overseas, it's easy to contact them with a WhatsApp. And then for work, I have an employee that lives in Paris and she comes for the summer and visits. And the only way for me to talk to her without racking up a ton of money on my phone bill is through WhatsApp. I had deleted it in 2023 at the end of the year because I thought she was done coming over and working. I reinstalled it this summer for clients for travel, and also she came back over and did summer work with me. So I was talking to her for that. And Paris is also 9 hours ahead. So when I do talk to her, it's usually late at night because it's morning time or afternoon for her. And I do use Teams for work. That's our main form of communication, but with the limitations in different countries, they can't always access Teams. So that's why I would talk to her on WhatsApp. But with Teams, we do hundreds of messages daily and calls. That's our main form of communication, as my job is based in California. So I work remotely. My boss is in communication with the works attorney since we do have NDA for clients and it's a privacy. I've talked to my employee about her pay and all sorts of stuff on WhatsApp. So she emailed me last night and said that she did try to follow up with the attorney last night, but with it being a holiday.
Okay, and I'm going to object to the hearsay, and this isn't in any declaration anywhere.
I would agree. You can't add that in.
Okay, and then I did, there was a protection order that was filed that went along with number 4 and number 5 request for production. In between going from Aaron to the other attorneys, there was, I guess, a docket notice was never filed. And so I filed that this morning and I haven't had time to serve them as the court opened right before this, but that is set for September 23rd. But that would kind of go with number 4 and number 5 request for production. I wouldn't be able to pay anything. I'm obviously having to do this by myself. I can't even afford an attorney as I've spent so much on fighting past allegations and everything. So I don't really think anything should be awarded for that.
Anything else?
No. I've tried my best to do what I can with what I have and limited resources without an attorney. So I'm just trying as good as I can.
Ms. Baldwin?
Thank you. I want to be clear, just because you delete an app on your phone, it doesn't mean that the data is gone. The app is just a conduit to essentially the server of that company. So all you have to do is reinstall that conduit. The data is still there. So this idea that I deleted it off my phone, that does not mean that all the data is magically disappeared. It's still there. You reinstall the app, all the data is still there with your same passcode in the same way that it works with your computer. If you delete your Outlook off of your individual computer, it doesn't mean that your email address has disappeared. You can get onto a different computer and access your email. So I just want to kind of provide some of that clarity. Again, she says, well, I'm not going to provide my Snapchat because I deleted it April 11th. But here she even acknowledges that even if her attorney didn't give it to her right away, that she had the request by April 1st. So well, hey, I deleted it. Then you deleted it after you are just fully acknowledging you deleted it after receiving our discovery request. She makes no response or no answer as to the files that are labeled Tombstone, as to the Google information and the calendaring information. So again, really doesn't have an excuse for why that happened and why these settings are changed, why the deletions are showing. So again, real concerns there. Nothing whatsoever to show that these communications are work related. She said, well, I've signed an NDA. She could have provided that very readily and easily. didn't. Not a scrap. And here we are, this was filed in July, and here we are in September. There's been plenty of time to provide a scrap of anything from her employer showing it's work related, and there's not a scrap. And so again, it's just her word of, hey, believe me, this is work related, when none of it really lines up. None of it really makes any sense that she would be doing this in this frame. And my clients provided gone through essentially the data and provided you with essentially, here's exhibit A, here's what she did, here's exhibit B, here's how she did it. This is the information we're seeking. And it is imperative that we obtain the information and have it, or that the court make those findings. Because again, parties benefit when they just withhold information and say, oh, well, that's going to be really negative for me, I'm just not going to provide it. So in these cases, it's critical that the court make orders that penalize parties appropriately when they don't provide.
So the court understands that you are representing yourself. At the same time, you have the same obligations under the rules as anybody else, including attorneys. And that I have the information that's in front of me that has been presented and provided. And that's what I have to look at and base things off of. So based on the files and record, the court does not believe the statements of you as a petitioner, and the court expects you to comply with the requested discovery. Based on the notes from the 26I conference, the needed information was discussed. Now, that information will be provided within 21 days of today's date. The court does grant the attorney's fees of $1,000 to the respondent for the necessity of having to bring this motion, and that's to be paid within 60 days. I understand your financial state. At the same time, when it costs the other party money, that's where that comes from. If the requested information is not provided as ordered, then the court will consider additional fees as requested by the respondent, including the penalty for the failure to provide unaltered documents. In addition, if the documents are not provided, the court will consider the striking of the responsive pleadings or strike any testimony by you as a petitioner on the topics that are being talked about. So if I understand correctly, and correct me, Ms. Baldwin, if I'm wrong here, I have Google, Snapchat, and WhatsApp. Is that correct?
Yes, Google, Snapchat, WhatsApp are the main ones in this case.
Okay. Do I just do like the downloads for it? Is that the information that Ms. Baldwin's?
So what I would suggest is Ms. Baldwin and Ms. Klopp is have another conference, telephone conference, to talk about just what she needs, because I'm not involved in the discovery part of it, so I don't know what has or hasn't been provided. But have that conference again with Ms. Baldwin, and that way it's clear as to exactly what she's looking for.
Okay.
Okay.
We can presentation.
So we have the GAL review and that I didn't address today, that I just set over to the 17th, but you said you set your matter to the 23rd.
Yes.
Maybe the 24th.
It was whatever that Tuesday is. They
Yeah,
said 3 weeks
September
from-
24th is the Tuesday. So did you
Oh,
put
yeah,
it
they
on the
put
23rd?
so that I might have to go out and talk to the clerk.
You'll have to refile that with the
Okay.
correct date because it'll be sent back. So why don't we just set these matters, including the GAL review and the presentation of the motion and your motion that you have onto the 24th. That makes the most sense.
Okay, so everything over to the 24th.
Correct.
Okay, very good. All right, very good. Thank you.
Thank you, Your Honor.
All right, that brings me to Klopp v. Klopp, cause number 19-3-00361-08.
we have Ms. Turnbull, we have Ms. Baldwin, we have Lacey Klopp here in the courtroom.
For a few things, but in this case, I'm actually going to ask the court continue this matter 2 weeks. Ms. Klopp didn't file her responsive materials until I believe late Thursday of this last week, and then the guardian ad litem filed materials yesterday. But given that, those are both very late filings, I think it's appropriate that we continue it so that my client can receive those, review them, respond if necessary. And I think if a response is necessary, that's why I'm asking for 2 weeks, just so that there's a response that actually makes it to the court file. And then we can have an orderly hearing. The materials that Ms. Klopp filed are pretty extensive and fairly large. And so I do think it's appropriate that my client have an opportunity to review them and respond if necessary.
There must be something I didn't see.
And it might not have made it to the court file based on when she filed.
When did you file it, Ms. Klopp?
Between that and the restraining order, there's been a lot that I had to file. It might have been Wednesday or Thursday, but I did send bench copies, so they were gonna have them on your desk.
Okay, so the request is to continue it. Any objections to that?
I just don't think it's necessary because it's been continued nonstop since May 14th. I just would like, to finally be heard and move on.
Part of the problem is I haven't read everything, so the other thing that I wanted to make sure is clear to everyone is I had talked about a motion needing to be filed to adopt the recommendations of a guardian ad litem report or modify a temporary order or anything like that. But there's no note or docket, so it's not actually noted up. And I recognize you're not an attorney, but it gets it on, so I know that's what's going to be done. Because with the many cases that I deal with, I need to know what am I actually doing that day.
Okay.
So that needs to be done as well. So I would not have considered that motion or that request today anyhow.
Okay, I just had figured the clerks would have said, I don't know,
Yeah.
just kind
Yeah,
of.
so you will need to do the note, make sure Ms. Baldwin and Ms. Turnbull get a copy of that.
So do I just go to the clerk's office and say that I need like a docket notice for the motion?
Correct,
Okay.
that should be. I guess I don't want to speak for the clerk's office. Can
I'll
she
just talk to
go
them
get it?
afterwards
Yeah,
and
talk
see
to
what-
them.
Okay, thank you.
All right. So if that's the idea, I'd like to set it over to October 15th, so everybody has time. That work for you?
That's fine.
Your Honor, that's the day I'm in
Oh,
trial.
that's right.
I can
Okay,
either do the 22nd, it's fine.
okay. So October,
Maybe the 22nd.
okay. Does October 22nd work for you?
Because there's really no other.
Okay. All right, so let's go to October 22nd.
We did have the presentation on, there weren't any objections to that, so I don't mind doing it today. I'd rather get that entered just because I'm worried that I'll get lost again. Okay.
Let me look at that.
That was just on the order to compel.
The protective order also getting that thing being moved out.
What's that?
The motion for the protective order for discovery.
Okay, so let's talk about the order first, compelling answers, and I reviewed it. It appears to be reflect what I had ordered. I didn't see any objections from you, and the court rules require you to put it in writing and file your objections. Did you? Okay. All right. I understand you may not approve of what's in here, but do you approve as to it reflects my?
Yeah.
Okay. All right, so Ms. Baldwin, I've signed. on that order.
Right.
And then if you want to address the, all right, so I reviewed the motion for protective order that was filed quite some time ago. May 28, 2024. Was there anything that you wanted to add in regard to that?
It was just had been lost between transitioning between Scott and then Miss Winkles and then me being by myself. So that's why it was taken so long between. I didn't realize that a docket notice was never done. But for the protective order, I know that she said the subpoena had already been issued, but it was also objected to. And from my understanding, there's like certain things that need to be done for an objected subpoena instead of just sending it out. And then there's also the number 4 request for production is in the protective order because it's asking for all text messages that I've had since 2022 until present. And I just think that's like overly burden and it would affect a lot of people's privacy that they have with me, including my work employees. I have 2 jobs. I have clients that I talk to. I just think that it's irrelevant to this case. It's overly broad.
All right, Ms. Baldwin.
Well, first of all, the protective order was regarding the subpoena for the phone records specifically. So she can't now say, ooh, let me lump in other things I want to protect. Now, she can't do that. It's only regarding the subpoena, and we filed a copy of the subpoena for you in with our response. Number 1, this is moot, that they essentially abandoned their request. For them to obtain a protective order, they have to actually file it and bring it before the court. It's not a way of just filing it and then just thinking that that acts as sort of a barrier. You have to actually bring your motion. You can't just file an objection. That's not sufficient to protect, and the rules in that are very clear. Number 2, when you look as far as it being overly broad, it was regarding 2 phone numbers. And we ultimately only ended up requesting, after I spoke with opposing counsel, I agreed to limit it from January of this year till when we sent the subpoena. So 2024 for 2 phone numbers for this period of time. So essentially it ended up being 5-6 months worth of time. So that's very direct, it's very limited. It's limited in scope, it's limited in time, there's no burden on her whatsoever, so there's no cost to her. These are phone numbers associated with people that we have concerns that would relate to 191 factors. And essentially what this is this is just a motion that's very buzzwordy, but with no substance whatsoever. And that's true also in the response that she puts in now. 4 months later, she puts in a response saying, oh, this is, invade my privacy. We're getting directly at, are you still communicating with this boyfriend you say that you've broken up with? That's a domestic violence risk. Those are the things that we're directly driving at. And again, time limited, scope limited, no burden to her. This is not privileged. This is fully discoverable. Discovery and discovery motions are not supposed to be used as a sword, and in this case they are. Is that Mrs. is trying to say, we bring this motion because I don't want you to see what these negative things could be. I don't want you to gain access to these things that would be problematic for your case. Everything that's not privileged is discoverable. And so in this case, they just have no leg to stand on whatsoever. The court should deny the motion and the court should grant fees. This is really a baseless motion, especially when this is targeted, it's direct, it's directly on point within case law within the statute. And at this point it's moot. So then bring it before the court when it's moot after the fact, 4 months after the fact, just there's no basis to have done so. Sorry, I am asking for fees to be awarded.
Any response?
Yeah, in the motion for the protective order that was given it talks about the subpoena, but it also talks to preclude discovery of phone records involving communications with third parties non-relevant to this action, and to limit the scope of discovery to exclude communications with family members and friends to protect against harassment and undue burden, which goes back to the number 4 request for production that was sent in the discovery. So it's not only the subpoena, but it also is talking about the number 4 request in that discovery. So it does mention it in the original motion that was filed in May.
So again, the court understands that you're not an attorney and all the ins and outs may not be known. The court agrees with Ms. Baldwin in regard to what she said. It was filed in May. We're here in October. It's not brought to be requested until several months later. Meanwhile, in regard to the subpoena that was sent, the court does not find that it was fraud. It had to do with the telephone records. So are you saying that you think that the text messages?
No, the subpoena isn't broad. It's very narrow between the two numbers. It's just that the discovery request for number 4 is overly broad. It's asking for every text message that I've ever received or sent since January 1st, 2022, until that discovery was sent in April of 2024.
When I read the motion, I didn't see text messages as part of it.
I don't believe that they are. Because that's, honestly, this is very old.
It was just kind of briefly in the relief requested stated the discovery of phone records involving communications with third parties is relevant to this, and then limit the scope of discovery to exclude communications. So that is talking about like the number 4 request in the discovery where it's asking.
Right, but so if you look at their motion, it's regarding. Okay, I'm happy to address that if the court wants me to.
No. The court doesn't agree that it extends to that. You need something very specific to the text messages, the interrogatories, if that's what you want, and bring a separate motion for that request.
Okay.
Okay.
Yeah,
And the basis for why, legal basis as to why those text messages shouldn't be disclosed.
Okay.
Okay. So in regard to the fees, the court does find and will grant $1,000 in fees for the necessity of having to be here on a motion that's filed back in May.
We just do presentation on that same date.
60 days, what?
Oh, we can just do presentation on that same date.
That's fine.
On the 22nd.
Yes.
That concludes this docket.
The next docket would have been on October 22nd, but I was sick and unable to get the stream that day. According to Odyssey, they reviewed the GAL report and the judge signed the presentation of orders. There was also a motion to adopt the GAL recommendations, but for some reason the judge denied it. The judge also denied Mom's motion for a protective order for her text messages. It's hard to believe, but this case is finally near its trial date. They currently have readiness hearings scheduled for both November and December, and trial dates in December and January. I think the judge was probably worried about whether this case would be ready in time for trial in December, so she set those second set of dates. I wish these two could work things out between them for the sake of their son, but that doesn't seem like it's going to happen. I think a trial is unavoidable for this family. There will not be any new updates in this case as this courtroom is returning to in-person hearings after November 1st.